Items for pronouncement of judgment. Item number 1, CRP 19 of 2024.
Petition allowed. Obliged.
Item number 2, IS Civil 2121 2025 with FAO 40 of 2025.
I dismiss.
May please, Lord. I beg to mention item number 3, Lordship. I may be allowed to withdraw this petition.
Mr. ABT Hawk, learned counsel for the accused submits that he has the instruction to withdraw this petition. Fair is accordingly allowed. That's of the A, number 7 to contestants. Dispose of on withdrawal.
Obliged, Lord.
Wait, please, the Lordship. Lordship, I have filed an petitional affidavit to make finding call for this. Hello. Wait, please, Lordship. But I beg to mention item number 10, my lord, on behalf of Mr. A. Rahman, my lord. Yes, some difficulties, so matter may be taken up by another another state, my lord.
After vacation,
My lord, I'll give the after vacation, my lord. Immediately after vacation.
is there your name, please?
Yes, Hawk, my lord, on behalf of A. Rahman.
As Hawk, learned counsel appearing on behalf of Mr. A. Rahman.
A. Rahman.
A. Rahman,
Yes,
learned counsel for the petition. Press for listing the matter after vacation. There,
immediately after vacation.
pardon?
Immediately after vacation.
Immediately after reopening of the petition.
My lord, my lord. Obliged. Yes.
Item number 43, I want to file affidavit in reply. May come after vacation, last hearing matter.
As for the learned counsel for the petitioner submits that in this petition, the respondent authorities have filed their affidavit in opposition. And she will file a reply to the aforementioned affidavit in opposition. And she applies for granting for some time. Fair is allowed to reschedule the matter immediately after reopening of the petition.
Obliged.
Item for motion, item number 4.
Meet with you, Lordship. But the last occasion, my lord, the government advocate was instructed to obtain some instruction, my lord.
Yes, who is appearing for the response? You have received instruction?
COVID is here. Yes, yes.
Paragraph number 4, Your Lordship. Forwarded his name. Four and 5 minutes.
Yeah, the four.
That is item number 5. Sorry.
Petition, respect of item number 5. Pardon?
It is there. I thought. Sorry.
Okay. So you will receive any instruction here.
There's not-
Can you obtain verbal instruction? You were not there. Miss A Talukdar, who is A Talukdar?
Yes, I'll look at.
A Talukdar. Junior government. Miss A Talukdar. But can I inquire to whom this matter was assigned? After some time.
Number 5. Item 5.
No one.
For our instruction is also awaited lawsuit. There was a direction to obtain instruction as to whether why the name of the petitioner was not placed before the state level committee. So that instruction is also awaited. Lawsuit was fixed after
Everything.
Yeah,
lawsuit.
already forwarded.
Because right.
That one, that
No,
But
this,
my other friend has received the instruction.
PLC has forwarded it to the SL.
Lordship.
Yes.
PLC has forwarded to the SLC. Now our part, once the PLC places the matter, otherwise our part is over. PLC is, the issue is the chairman.
yeah, already forwarded. to
Word.
Devi.
Item 5.
Her name is not. Yes. Not-
In that case, lordship can dispose
Yes.
of.
Yes, Malad. Vanessa Khatun, no?
That's right.
Instruction item.
Heard Mr. N. Sharma, learned from production. And also heard Mr. P. N. Sharma, learned.
I am for the number 4 and 5.
Elementary education department. And Ms. K. Pupan, learned. Junior government advocate for respondent number.
Document number 1,
That's
1, 2,
number
3.
1, 2, 3.
Yes, and 6.
1, 3. This petition on Article 226 of the Constitution of India, the petitioner has challenged the OM dated 18/9/2024 issued by the Commissioner and Secretary to the Government of the Personality Department. Take memo number ABE.104 from 2024 from 90 dated 90. And also right for issuing direction to the respondent over is more particularly associated to consider the proposal of the petitioner as per recommendation made by the TLC on 21/2021. Having appointed on compassionate ground against the vacant post of assistant teacher in LP school as per the qualification in accordance with the Switzerland schemes for policy dated 1/6/2015. Mr. Sharma learned from for the petitioner's understanding. The father of the petitioner, namely, let Bakhtiar Ali Sheikh, was serving as head teacher of 1082 number of Sutto Bazar Suto Bazar or Suto Bazaro?
Suta Bazar. Suta Bazar. Suta Bazar.
Suto Bazar.
Suta Bazar.
LP school under the Deputy Inspector of School, South Salmara, in the 10th district
Suta Bazar.
of Dhuburi, now South Salmara, Assam. Who died in harness on 30th May 2002. That is before 2007. After the demise of his father, the petitioner applied for appointment under sufficient ground within the prescribed time before the concerned authority as per prevailing norms in the state. But the petition filed by the petitioner was not considered by the respondent authorities, for which the petitioner approached its court by filing WPC number 2050 of 2012, praying for appointments on compassionate ground. The said state petition was disposed of high order dated 23rd, 2022 with a direction to the respondent consider the case of the petitioner as per the government circular dated 28/2005 in a period of 3 months. Thereafter, the district level committee, South Salmora, on 21/12/2021 has recommended the name of the petitioner for being appointed on compassionate ground against vacant post of assistant teacher in LP school. Thereafter, the deputy commissioner, South Salmora, has forwarded the proposal of the petitioner as per format to the government of Assam. Education Certificate Elementary Department is put for placing the same before the SLP meeting for further consideration as per the
Bazar na Bazar.
but the petitioner is not aware of
Now what?
as to whether the matter was placed before the SLC or not, and no order was communicated to. And in the meantime, the commissioner and secretary to the Governor of Assam Personnel B department has issued the interim office memorandum dated 18/9/2024, where a decision has been taken that no case for appointment on compassionate grounds shall be entertained by any administrative department proper before any reason whatsoever, nor be placed before the SLC and ELC for recommendation of the candidate for appointment on compassionate grounds. So Sharma further submits that each of the petitioner was recommended by the DLC South Salmora on 21/12/2024. That is much earlier than the date of issuance of OM on 18/9/2024. Above, Mr. Sharma submits that this petition may be disposed of by directing the respondent authority to place each of the petitioner before the next available SL3. Mr. Sharma and Ms. Pupon learned nothing from it for the elementary education department and junior government advocate respectively submits that they have no objection to the event of disposing of this rate petition by directing the respondent authority to place the matter before the next SL3. Better. Having heard the submission of current to put the party, I have already gone to the document that I got. And also part of the recommendation of the DLC dated
21.
dated 16/1/2020. But the basic facts here in this case are not
Really.
the father of the petitioner died in earnest while he was serving as head teacher of 1482 numbers of Suto Bazar or Suto Bazaro.
Bazra.
Suto Bazaro LP school, where the Deputy Inspector of School, South Salmara. In the district of South Salmara. South Salmara, on 30th 8 2000. The petitioner then applied to the respondent authorities having appointed him on compassionate ground. The said petition was not attended to by the respondent authorities, for which the petitioner had filed one petition WPC number 2050/2004, which was disposed of by order dated 23rd 2024 with a direction to consider the case of the petitioner as per circular of the government dated 28/2008 in 3 months. But the district level scrutiny committee held in 21/12/2021 had recommended the petitioner having appointed on compassionate ground against vacant post of assistant teacher in health. But the said recommendation has not yet been placed before the SLT for further consideration. In view of the OM dated 18/9/2024, but it appears that the case of the petitioner was recommended by the TLC on 21/12/2021, months before coming in force of the OM dated 18/9/2024. Thus, taking note of the aforementioned facts and circumstances and also considering the submission of the net conflict for both the parties, this court is inclined to dispose of this petition by directing the respondent authority to place the case of the petitioner before the next available PL. In the event of such matter, in the event of the matter of the petitioner being placed before the SLT itself considered as deep in accordance. Let the aforementioned exercise be carried out in a period of three months.
Yes.
From the date of receipt of certified copy of this order. Order. Place the same before the respondent within a period of 1 week from today.
Matter number 6.
May it please your lordships. Your lordship, the matter pertains to the Mukhya Mantri Niju Moina Asani, your lordship.
Mm.
The petitioner school is aggrieved because of their non-inclusion in the list of beneficiary venture schools. However, similar matters have come up before Honorable Justice Nelson Snyder, your lordship, and it was disposed of with a direction to submit representations, your lordship, to the DSC.
Do you have the order? Copy?
Your lordship, due to paucity of time, I could not get a printout, your lordship. I have
You
the number.
obtain it, you place it before this court after some time.
Yes, your lordship.
Item 7.
May I please your lordship?
Hmm.
Lordship, may kindly pass over the matter for the time being.
Time being.
Yes, lordship. I'm obliged, madam.
Item 8.
May it please the lordship.
Hmm.
Lordship, last time we were approving submitted instruction, lordship. That instruction is only given a categorical statement, lordship. So only the mission director is the right to the allowed to the dice court, lordship.
Mission director is
Is the allowed to the dice court. The DOBO has no right. So therefore kindly dispose of my petition and given direction to allow my online application. Only two options are there, saying one is a government aided, another is a private option. So they are, ask my client, they say only two options are there. They given a categorical statement. Accordingly, the online application has been submitted through the request ID so and so, but the application is revert back from the state mentioning to change the managing of school from the gov aided to unrecognized. But the online system does not allow to unrecognized option to be selected as a school management.
Hmm.
So as per the speaking order, Lordship, page number 27, like petition,
Page number
27. Mission Director. Samudra Sikka. Speaking order, Lordship. You are hereby request to apply the online Discord class portal for allotment of Discord in September ME school as per the option available here.
yes.
But if in this matter, the EPC and the SSA are the main parties. I'm appearing only for the elementary education. So Mr. P. Chaudhary generally appears, but I think
I will take notice of that. Okay, SSA and PT is there. But we will issue notice as it says.
No, Mr. Bora on the other day,
But P. Chaudhary appeared.
Ishudari
Well,
appeared
sir,
and
that-
he
I-
produced some instruction before
Let
this
it
court.
come after some time, I will inform him, my lord.
He is present in the court.
Well, I have not seen him today, my lord, but this case is allotted to him only. Let it be taken after some time, I will inform him.
After some time.
Lordship.
Okay.
Lordship, only may I pray for taking it after some time.
Well, in fact, my lord, they have taken the action of the school, the college, my lord. College principal is not a party, college is not a party.
Let Mr. Priya come, Lordship. There is nothing, Lordship. Probably, Lordship.
May I please, your lordship. In this matter, your lordship, in the last occasion, instruction was called for you. Here in the petition, he has been transferred, but no such release order has been issued.
Release order will be issued by the headmaster.
Administrator. And accordingly,
Yes,
Lordship,
instruction, I heard.
We have not received your lordship instruction. Because the release order will be given by the headmaster, your lordship. He has to be
No,
has to
therefore,
go.
therefore, it was directed that
Lord-
from the inspector of concerned school, no, concerned district.
Lordship, yes, your lordship. We have not received the instruction yet.
No, you can obtain verbal instruction
Lordship, after some time, then
after
I'll-
some time.
May please your lordship.
Hmm.
My lord, here also instruction was sought, my lord. Here we must challenge the executive order, my lord, which has superseded judicial order, my lord.
Take it.
Lordship, here in this case, Lordship, that additional senior government advocate Rahul Dhar will appear. He is leading all these cases.
Oh,
Rahul Dhar.
My lord, I'm sorry, my lord, I was in the other court, my lord.
okay.
My lord, we could not so receive any instructions because of yesterday's, my lord.
Yeah.
There was a holiday. Otherwise, even my lord, I will try to satisfy my lord. That this writ petition, my lord, what the writ petitioner is, my lord, seeking, my lord. Little misconcept, my lord.
How?
I'm saying that. My lord will come to first page number 15.
Page number?
15 of the writ petition, my lord.
Yes.
My lord will see, this is an order passed in writ petition number 2/888/25.
Hmm.
Here, the writ petitioner is Abdul Kalam Azad. One writ petition, my lord. There was an order in this. Now page 18, my lord, the operative part. Page 18, my lord. Having regard to the peculiar facts and circumstances of the case, and for the ends of justice, I am of the view that the petitioner's case deserves to be considered in the light of the aforesaid observation. As such, this writ petition is being disposed of at this stage of motion hearing by providing that the petitioner's case be considered by the SLC in the light of the observations made in para 9 and 10 of the judgment and order dated 3/4/25. An appropriate decision as may be prescribed under law. So, my lord, this is the specific direction from this honorable court in terms of that series. There are 67 writ petitions, my lord, altogether. And here, a coordinated bench of Honorable Justice Michael's Thangamas order, my lord, dispose of all the writ petitions. What is the order, my lord? It is not annexed here. I am, my lord, placing it before your lordship. Then, my lord, I will come why it is misconceived, my lord. My lord, there was a series of writ petition, my lord, 67 writ petition. So, my lord, the operative part, again, I am going to page number para from 8. 9 is a no issue, my lord, 9. Para 9, my lord. This is the order, my lord. There was a specific direction on us to comply with the order. This is the first which has fallen from this court, my lord. We have to comply. And that SOP is, my lord, in compliance to this order, my lord. Not any other thing. We did not take out that SOP. This SOP is fallout of this order. We have to consider how we consider that is the SOP. First thing. So, my lord, para 9. In view of the consent of the learned counsel for the parties, all the writ petitions that are pending as of today on 3/4/25 in the Guwahati High Court, which have to put to challenge the impugned OM dated 18/9/24 are to be decided as follows. So, my lord, my lord will mark, my lord, there was a direction pending as on today, that is 3/4/25. That was specific direction on us. That is bound on us. We are bound by that honorable court's order, my lord. So, my lord, how is to be done in 9 and 10? There is a direction that consider this bunch of writ petitions, my lord. There are all total 67 writ petitions, more than 170 writ petitioners all total in that series, my lord. This is the order. Now, my lord, coming back to this, page 15, my lord, here the writ petitioner is Abdul Kalam Azad. What my friend is trying to seek, my lord, something out of this order, my lord. These petitioners, the current writ petitioners, are not a part of this writ petition. They did not have this direction. This is not a PIL, my lord, that some order has been passed and I come seeking a relief. It's a service matter, my lord. There has to be, my lord, a clear-cut vested interest. That order was passed for Abdul Kalam, a separate writ petitioner. He is not before your lordship. Here the writ petitioners are, my lord, all different persons. Saptami Turi, Ajay Kumar, Amit Das, Lakshmi Rani. They don't have, as of today, they did not get any, my lord, relief from this court. They don't have any such order to that on SLC, DLC or personal department or the government of Assam to give them any relief. Now, my lord, let us come into what is the SOP, my lord? Page number 19. Page number 19, my lord. My lord, this executive order.
Yeah.
My lord, first we say that our OM we have come up. Now the second para, the compliance starts. And whereas in the light of various judicial pronouncements, particularly in the light of order dated 3/4/25, that is what I place before your lordship. passed by the Honorable Guwahati High Court in this 342 Abdul Kalam and similar other writ petitions. That is the connected, my lord, all the cases. Government has decided to formulate the following standard operation procedure to uniform the effective disposal of the matters relating to the appointment of compassionate appointment. My lord, where we are wrong. There is a specific direction from this Honorable Court. Specific direction that you dispose of these writ petitions. So, my lord, how do we do it? We have to go for a procedure. How is to be placed? We have to call for the, my lord, applications. Those are pending. Because, my lord, if you don't do it, a contempt is hanging on our head. A contempt is hanging, my lord. And, my lord, the very interesting thing is that the writ petitioners who are before your lordship, they don't have any order. They are seeking an order who is not before your lordship. The thing is that they have a remedy. Either they go to the coordinate bench, seek and, my lord, review order of this, that they have to say that yes, my lord, we are also want to be part of this order. Otherwise, my lord, if there is this writ petitioner, as of today, they don't have any order. There is Abdul Kalam, my lord. Maybe his order, the government has already decided because he has a direction, but they don't have a direction here. So, my lord, now the issue here rises is, if my lord passes an order today, staying this SOP, meaning thereby my lord is interfering with the order of the coordinate bench. It is an appeal in disguise. It cannot be, my lord. Either they have to go before a division bench if they have a problem with this SOP. Because we are just complying the order that's been passed by the direction of this Honorable Court. If my lord said don't go ahead with this order, we will not go, my lord. Because, my lord, we are bound by the order, my lord. Order of this Honorable Court. Honorable Court said that you go ahead. We have, my lord, we are just trying to comply. They don't have any order. If they had any order, my lord, we would have, my lord, considered them also. This is a separate order, my lord. We are complying a order of this Honorable Court. We will respond to this, my lord. My lord will issue notice. Will an outcome of the writ petition, if they get relief, they will get relief. My lord can always, in 226, my lord can always modify the order. There is no bar. But, my lord, as of today, my prayer would be, my lord, if my lord passes any order, my lord, it will be interfering with the coordinate bench order, my lord. Because we are just complying the order of this Honorable Court. We are doing nothing more. This is the order, my lord. Specific order. I place it before your lordship.
Yes, madam.
My lord, here the petitioners in this case, my lord, they have already filed writ petition and their writ petitions are pending. I have given the numbers.
Pending, my lord.
Let me finish.
That was my
At para 2, my lord, page 5. I have given the case numbers, and in these cases, my lord, these cases are pending, and in these cases also we have relied on the, my lord, order dated 6/4/2025 passed in WPC number 2888 of 2025. And here we have relied on this decision, my lord, this order, the order here, my lord.
Let notice go then.
Only not, nothing more, my lord. Because we are not, my lord, overriding any judicial order. My lord, we are just following the judicial order. What is direction on us? We are just going by that.
And the petitioner's cases are, my lord, they already, my lord, forwarded, recommended by the DLC. And in the list prepared for sending before SLC, all the petitioners' names appear, my lord. Only because of the office memorandum, the processing stopped, my lord. So, my lord, we have approached this honorable court after this judgment dated 3/4/2025. And so in our case, notices were issued. And, my lord, it is pending for final disposal. And here we have relied on this order, my lord, that is subsequent to the, my lord, order dated 3/4/2025, my lord.
Pardon, S.B. Chaudhary, Learned Counsel for the Petitioner, Mr. Ardhar, Learned Additional
Senior government.
Senior Government Advocate for the State Respondent. Mr. Hor, Learned Additional Senior Government Advocate for the State Respondent, State. though he was asked to obtain necessary instruction, yet he could not obtain the same. However, it submits that the SOP was issued by the government in compliance order of the order of this court. In order to implement the order being passed by this court in WBC number 342 of 2025, by order dated 3/4/2025, 4/2025, and that addresses notice may be issued and he will file his counter affidavit. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that honesty of the respondent returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Door entered appearance and received notice for all the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day. Place the matter after 4 weeks. The meantime, Mr. Door learned counsel. No, learned additional senior government advocate file the counter affidavit.
File deeply obliged.
4 weeks.
Item number 13.
May I please touch? Well, in this case, my learned friend supposed to take instruction.
Yes, but in a similar matter, the Honorable Court has already directed the respondent directed the petitioner to file appeal before the appropriate authority, and that appeal should be considered within a time. Similar order already passed. Similar methods.
Let's say you file an appeal then.
Lodge. Well, Annexure 4, there is only one medical note that may also be considered.
No,
You
Lordship,
enclose that document also with your representation, with your
Right.
appeal.
Lodge.
can consider.
Or Mr. K.R. Roman, learned counsel for the petitioner, and as Borwa, learned CGC for the respondents. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the rejection slip dated 9/2025, Annexure 3, by which the respondent authorities have rejected the candidature of the petitioner for the post of constable with GD in the Central Armed Police Force CAPF on the ground that height of the petitioner was found to be 164.6 cm, whereas the requirement was 165 cm. Mr. Roman, learned counsel for the petitioner, submits that though in the rejection slip within bracket annexure 3, it has been mentioned that if he is not satisfied with the count of rejection during PST, then he may defer an appeal in writing to the authority on the same day, but the said facility was not extended to the petitioner, for which he could not defer an appeal before the authority concerned. Mr. Roman, drawing the attention of this court to the annexure 4, at page number 45 of the petition, which was issued by the Guwahati Medical College Hospital, submits that the height of the petitioner when measured in the Guwahati University was found to be 165 cm. 165 cm. Then as such, the rejection slip issued by the respondent authorities to the petitioner is illegal and arbitrary, and therefore it is contended to interfere with the same. Per contra, Ms. Borwa, learned CGC, obtaining necessary instruction, submits that Similarly situated candidates approach this court by filing WPT number 5411 of 2025. When the said writ petition was disposed of by a coordinate bench of this court by order dated 15/9/2025. Granting liberty to the petitioner to prefer an appeal before the competent authority against the rejection of his candidature. Then further directed that in the event of filing such an appeal within 2 weeks, by enclosing certified copy of the order, the same shall be considered and disposed of by a region order as expeditiously as possible, but not later than 30 days from the date of filing of the appeal. And in view of the aforementioned and relied upon the aforementioned order of this court, this court submits that the present writ petition may also be disposed of by issuing similar direction. Mr. Rahman Learned Counsel for the petitioner submits that he has no objection in the event of disposing of disposing of this writ petition by granting similar relief, like the petitioner of WPT number 5411 of 2025. Accordingly, taking note of the submission of learned counsel for both the parties and as agreed upon, this court is inclined to dispose of this petition by directing the petitioner to file an appeal before the respondent authority within a period of 2 weeks from the date of receipt of certified copy of this order. Enclosing this writ petition along with the annexer. Along with the annexer number 3, which is annexer number 4, which was issued by the Guwahati Medical College Hospital on 5/9/2025. And in the event of such appeal being preferred by the petitioner, the respondent authority shall consider the same within a period of 30 days from the date of receipt of certified copy of this order. The petitioner is directed to obtain a certified copy of this order and to place the same before the respondent authority within a period of 1 week from today. In terms of this, WPC is that highly public.
Item 14.
This matter was listed there before yesterday, my lord. I have seen the executive order furnished by the respondent, my lord. My lord, my case is that before introduction of the office memorandum, my case has already been recommended by the DLC. And the recommendation is page 30 on 18/1/2017. Serial page 32, serial number 9. Against clear vacancy of grade 3. Then, my lord, my case was placed before the SLC on 23/12/2019. Page, my operative pass, page 36, serial number 4. By holding that I am not eligible for grade 3 post because I do not have HS science pass. Then I approach this honorable court, page 39. Page 40 on 13/3/2024, before the office memorandum, this honorable court directed for consideration of my case against any vacant post. Thereafter, I was not aware about the decision of the SLC. Then OM has come and the notice has been issued. In terms of the notice also, I have submitted the particulars on 15 because the last date was 15/9/2025. And I came to know about the notice on 11. I immediately approached this honorable court on 15. The writ petition has been filed on 15. On the same date, I have submitted the particulars in terms of my original recommendation as well as direction passed by the honorable court. So my executive order is not against me. Only this is the reiteration of implementation of the judgment passed by this honorable court. So there is in the notice, there is a provision that I should mention the writ petition number along with the certified copy. My lord, page 53, serial number 11. 10 is the date of filing of this writ petition number so-and-so, challenging the 18/9 and certified copy of the honorable court judgment dated to be enclosed. since I have submitted the documents, my case has been recommended by the DLC. And the Honorable Court also directed for placement of my case before the SLC, before the evening notice came to be issued. So in compliance of the notice, I have also submitted the particular. Only requirement is to produce the Honorable Court's order regarding challenge of the when. So my humble prayer would be that.
No, if this order dated 13/3/2024 is already there,
Yes, madam.
where it is directed to consider the case of the petitioner to any post commensurate with his.
My lord, they
education
have not considered because of the when, my lord, test 43. In view of test 43, they have not considered, they have not placed my case before the SLC. Therefore, I was waiting.
Yes, Mr. Sutia, you are appearing here.
Yes, my lord. My lord, in this case, what happened, my lord, he is saying the page 53, the office order notice. It is not for him because his case was from 16 and 16 here, this case was recommended by the DLC against single post, my lord, which is against the law. They cannot, my lord, it must be a 5%. To be a 5%, it must be 20, more than 20. Then it is one single post they have recommended. However, that is considered by the SLC.
Hmm.
SLC considered on page 36 says that his qualification is not met with the recommendation. That's why, my lord, petitioner's case was rejected. Again he come, my lord,
No.
it is a confession of it is not a matter of right. It is a, my lord, scheme. Where is the immediacy that this Deborah Tibari case has come? And Lord kindly see the office memorandum.
Mr. Sutia will not go into the merit of the matter. So there is already a direction of this court dated 13/3/2022 to consider his case.
That was considered, my lord.
Not
No,
considered.
no.
Not considered.
After this order, the matter was not placed before the SLC because of the way.
Yes.
That is, my lord, order dated 13/3/2024.
Yes.
That is.
Yes.
Yes, yes, my lord. Oh, against this order, my lord, whether SLC considered or not, I don't know.
Not
Till
one.
today, today motion is, well, let it notice be
No.
issued. And it will, I will obtain.
Meantime, it will be too late. In view of this order, we are disposing of this petition. Let the matter be placed again before the SLC.
Yes.
His cases survive only the order dated 13/3/2024. Otherwise, he says no case.
Yes.
Because Ochurondor does say, if it is pending for 2 years and there is no vacancy, it has no vacancy. That is there. Okay, I will obtain instruction regarding this order.
Let the SLC consider the matter.
Yes, yes, yes.
In
That is-
accordance with
That
law.
is true, Malad.
In accordance.
Already judicial order is there.
Yes. We are
Obliged.
disposing of this.
After vacation,
No. Dispose
No,
of.
disposal.
oh, let's say dispose of. Oh, no, no problem. Obliged.
A talukdar is, she is no longer in government as government advocate, your lordship.
Okay.
So I'll bring instructions after vacation, your lordship.
Art is the case of learned counsel for the petitioner and also art is the case of
Your
learned.
lordship, they have not served extra copies also. They have not served extra copies.
Okay.
Notice may be.
For the state respondent, Ms. Okan submits that though fight order dated 38/5/2025. Ms. A. Talukdar, learned junior government advocate was asked to obtain instruction. But Ms. A. Talukdar is no longer in the said position and she will bring the instruction and she prays for granting her some time. And also, write for direction to the petitioner to furnish extra requisite copy of the petition.
Well, notice may be issued, Malik. Notice or not issued. Notice may be issued.
Letter of the inspector.
Right.
Accordingly, it is provided that Mr. Hawk learned counsel for the petitioners and furnished extra requisite copy of the this is a the matter immediately after the opening of the paper.
Standing item 6.
Your Lordship, I've given a copy of the order.
So AO one similar direction.
Yes, Your Lordship.
Okay. Ms. Mutsari, any objection?
No, no, no.
Okay. We are disposing of this.
Standing item 7.
May it please your Lordship. Lordship, the petitioner herein was appointed as an assistant teacher in 1991, and he was serving in Beltoli ME Madrasa, which was later converted to Beltoli ME School. From 17/4/2007, he was appointed as in charge headmaster. Until the passing of the impugned order, he was serving as in charge headmaster. On 7/7/2025, the impugned order has been passed, Lordship. Page number 13. Lordship, we are not, transfer is naturally a consequence of service. But in the instant matter, a punitive transfer order has been passed without conduct of any disciplinary proceedings in the with regard to the findings that have been arrived at without conducting any inquiry or any departmental proceedings. Now, this punitive transfer order has an effect on my promotion to the post of headmaster. The respondent number 3 has initiated the process of promotion to the post of headmaster in UP schools.
Okay. How the transfer order is punitive?
If your Lordship kindly sees this third paragraph, Lordship, page number 13.
Yes.
Whereas it has been observed that the following charges are leveled against Mohammed Saurab Ali, the petitioner, assistant teacher, acting as in charge headmaster of the said school. Firstly, failure to serve hot cooked meals under PM portion on 6/6/25 and instead providing biscuits to the students. Repeated supply of insufficient cooking materials to cook helpers, leading to denial of meals for students. Poor maintenance of MDM books of accounts. Mishandling of public funds and conduct resulting in deprivation of students' entitled benefits under PM portion. Such conduct has resulted in the failure to implement government welfare schemes in accordance with prescribed guidelines, thereby adversely affecting student welfare and breaching administrative norms. All these allegations of administrative inefficiency or the greater interest of students have not been looked into by way of conducting any inquiry or departmental proceedings. And this will have an effect on my ACR, which will again be the main document for promotion to the post of headmaster. So on that ground, I'm challenging this transfer order. I have already joined in the new place of posting where I have been transferred, but this particular order is punitive in nature and it is affecting my ACR.
May it please the Lordship, as far as the department stand is concerned, the report given by the DEO says that there has been operational irregularities in this particular case. And my lord, regarding 4 points, my lord.
Is there any disciplinary proceeding?
My lord,
was conducted.
in this case, my lord, the full instructions I have to get, my lord, because of the fact that it has come for motion today for the first time. So I therefore pray that, my lord,
Date I had to wait for time.
my lord, today, therefore I pray that my lord will issue notice, my lord, and my lordship will fix it. My lord, we'll get our instruction to file a consolidated affidavit.
Yes, Lord.
We'll file a consolidated affidavit. So my lord will fix it after the vacation, my lord. And because my lord, there happens to be operational irregularities, my lord, and these are of great nature. Let me get my instruction whether
Okay.
procedure has been followed or not.
Overall, learning council for the petitioner. Sorry, I forgot.
I'm preparing for all of it, all the responses.
Learning council for the respondent.
Element.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 7/7/2025 issued by NIMO number -76C 02 of 2011 issued by the director elementary education Kaili Paraguay. It is to be noted here that by order dated the respondent number, the director, second elementary education department. Elementary education deliverer, the respondent number 2, transferred the petitioner from Beltoli ME School and posted to Rajabari Sologuri ME School against vacant post of Ojan Datta, assistant teacher under Block Elementary Education Officer Batodwa, with immediate effect. Ms. Agora, learned counsel for the petitioner, submits that the impugn transfer order assumed the character of a punitive nature as some allegations are leveled against the petitioner in the said order and no inquiry was made to ascertain the veracity of the aforementioned allegation. And as such, it will have far-reaching consequence in the service record of the petitioner, and under such circumstances, she has contended to interfere with the same. Ms. Agrawal further submits that, however, in compliance of the said order, the petitioner has already joined in its new place of posting. Mr. Kupon learned and counsel for the respondent authority submits that he may be the SSS notice may be issued and he will file consolidated affidavit immediately after reopening of the vacation and press for listing the matter thereafter. There is accordingly allowed that the issue notice to the respondent returnable in 4 weeks, except however no formal notice is required to be issued since Mr. Kupon entered appearance and received notice for all the respondents. However, extra requisite copy of the petition will be furnished to him during the course of the day. Please submit it after 4 weeks. In the meantime, Mr. Kupon furnished standing counsel shall file consolidated affidavit.
My lord, PPF.
Obliged, lord.
Lordship, I'm appearing on behalf of Mr. Kebia. Your Lordship, he's severely fallen ill due to which he couldn't come. We're seeking for adjournment. Kindly fix the matter after vacation.
After vacation,
Yes, Your Lord.
the secretary learned advocates of both the parties, let's establish the matter after.
My lord, immediately reopening, my lord.
Quickly after reopening of it.
Obliged.
Please, your lordship. In this matter, the respond numbers 1 and 2 are to file their affidavit in opposition, my lord. It's a matter wherein, my lord, the medical officers of homeopathy are seeking parity of remuneration at par with medical officers of Ayurveda. The response are to file their affidavit, my lord.
Now,
On behalf of Mr. B. Govind Thakur, I'm paying for some time, my lord, after vacation.
after vacation,
It's 23 matters, so it may be filed by next date.
no, they have already filed their affidavit.
No, my lord, they are yet to file.
On behalf of
Yet to-
NHS,
Respond numbers 1 and 2 are yet to file. Respond numbers 3 has filed.
Okay, 1 and 2 had not filed. Part, Mr. You could have played.
You Pathak, my lord.
You part of learned counsel for the petitioner. And Miss
A. Bora.
A. Boda, learned counsel for the learned counsel appearing on
And
behalf of Mr. B. Gogoi. Learned standing counsel for the respondent number 1 and 2. 1 and 2. Ms. Boda submits that Mr. Gogoi is not present today.
He's in another court matter.
Okay.
Sometime-
Ms. Boda submits that Mr. Gogoi is busy in some other court and she tries to between the matter immediately after the opening of the vacation. There is accordingly adopted the meantime, respondent number 1 and 2 may file their affidavit in opposition.
Highly obliged.
Please allow. My lord, we have challenged, my lord, page 34. A communication has been given as a second wife as a legal heir, my lord. Because as per Hindu Marriage Act, my lord, does not permit. Page 34 is the impugnment. On the last occasion, your lordship was pleased to ask for the instruction, my lord. No affidavit has been filed.
My lord, yes, my lord, we have sent a letter on February 2024. Sometime maybe granted after vacation, my lord, in the meantime, I will obtain the instruction. That was he is challenging the circle officer's order. Circle officer, whatever he have found in the field verification, that has been projected. So second wife is there. He is saying that as by Hindu law, that will be decided by the my lord AG and authority concern, school authority concern, whether they enter or not. Now,
No,
circle
not for the
officer,
entitlement.
circle officer report is on the field verification. What he have found, that has been projected. Idea about after vacation, I will obtain it.
That is the only one, my lord. As
Yes,
per
yes,
Hindu law, my lord, I am not come for the pension or any other benefit. Issuance of this communication, my lord, that is put under challenge. Because lordship is aware, my lord, as per Hindu Marriage Act, my lord, 1955, second wife has no status. But here, my lord, page 34, they have shown as a wife, my lord. Pension rule, anything does not show, my lord. They have to file affidavit, my lord.
Learned for the Sir Sophia. Learned. In what capacity you were appearing here?
My lord,
In what capacity?
I am my lord, additional senior government advocate.
Additional senior government advocate. For the respondent number
I am for respondent number, my lord, 2 and 3, my lord.
2 and 3. That is a headache
For 1 lot.
1.
headache for what? Then your capacity? Yes,
Actually, counsel.
Council Revenue Department.
standing council revenue department. Mr. Sophia Samit said he may be granted some time to complete the inspection. You want to file affidavit?
We will file affidavit, my lord.
Then he will bring the same on record by way of an affidavit and press for listing the matter immediately after the opening of the bid. Where is allowed, this is a matter immediately after the opening of the bid.
Item 18.
Obliged, my lord.
Please, your lordship. The affidavit has not been filed yet.
Lordship, we have sent it for vetting, your lordship, so lordship will
Vetting.
allow some time.
When can we expect it?
Lordship, immediately after the vacation.
Heard, Mr.
Yes, Gautam, your lordship.
Yes,
Gautam.
learned counsel for the petition and sorry for the second of her sorry summits that affidavit in opposition has already been prepared and sent for vetting. And she press for listing the matter immediately after the opening of the petition. There is allowed to list the matter after
Lordship.
immediately after the opening of the petition.
Lordship, a date may be fixed, your lordship. The petitioner is retiring on 30th.
October 27th.
No.
27th.
Obliged.
Obliged, your lordship.
Item 19.
May please your lordship. Lordship, I am here on behalf of Standing Council of Animal Husbandry and Veterinary, MM Kapati. Lordship, affidavit is filed for vetting. We will file affidavit within 2 days. Lordship, kindly.
Lordship, herein, the brief has been taken back from us, Lordship, and we have lost contact with the petitioner. So our names may be stuck off, Lordship. Let them file their affidavit.
You have issued announced
Yes, Lordship.
Heard, Mr. Sharma for the that needs
I put it.
Heard,
I put it.
Kotoki. Learned counsel appearing on behalf of
MM Kapati.
MM
MM Kapati. Standing Council of Animal Husbandry and Veterinary.
learned standing counsel for the animal husbandry department. And Mr. Affirmative for
Fountain jet.
AG.
Respondent number.
Respondent number 3. Okay. So Mr. Sharma submits that the petitioner has already taken back the brief from him, that he has already issued NOC, and he prides for deleting his name from the house list.
Whole sets of advocate lordship. The whole set of advocates have gone lordship. Because as Shruti Sharma Hazarika was also along with me lordship. So she is no longer there. And my senior has already been elevated. So the whole set goes lodge.
The name of Mr. Sharma and Ms. Shruti Sharma Hazarika, and also his senior, maybe struggle from the house list. Research will do the needful in this regard. And also the research will issue notice to the petition by registered post with DD and also by the process within 2 working days from today. Please submit thereafter. Vacation.
I'm obliged, Lord.
Talukdar,
My lord,
you have gone through the files.
five. Yes, my lord. And but your lordship query I have not found in this file, my lord. From 16/6/2009 to 30/6/2014, this service was not regularized. Only, my lord. And regarding, my lord, disciplinary proceeding, my lord, I found one communication from the Undersecretary Government of Assam, my lord. Due to, my lord, in here, may I read, my lord? The DE Assam Authority report informed the department that an inquiry was held and the hearing was conducted to examine the case of the petitioners. And on examination, the committee found that after suspension of the petitioner, Sri Dilip Kumar Sharma, and in order to finalize the departmental proceeding against him, a so-called notice was issued by the DU Gulagat firstly on 6/2007, then again on 25/2008. But he remained untraceable and failed to submit any response to focus. Subsequently, 2 FIRs was lodged on 23/4/2008 and 18/8/2008. And a newspaper notice was also published on 22/1/2009. But despite of all efforts, the petitioner remained untraceable and attained superannuation on 36/2014. Hence, departmental proceeding against him could not be concluded till his superannuation. That was regarding, my lord, departmental proceeding. In respect of salary being paid to the petitioner during his absence for 3 years, as per report of the inquiry committee submitted by the DE Assam, it has been stated that his salary for the period with effect from 1/1/2003 to 28/2/2006 was rightfully paid to the petitioner, as he was found to be perform his duty as assistant teacher, Soramuk ME School, till 28/6/2006. As per the inquiry report, the report dated 8/12/2021 was submitted by the then DI of school Golagat, wherein it was stated that Sri Dilip Kumar Sharma, assistant teacher of Suramuk ME School, had been found absent in his duty with effect from 1/2/2003. As per the record of service book, but he was drawing monthly salary till 2006. As per acquaintance rule of Suramuk ME School. However, later it was found that the report was wrongly submitted based on service book record without physical verification of the teacher's attendance register. As per teacher's attendance register, it has been found that he has actually rendered his service for the period up to 28/2/2006.
and accordingly receive monthly salary for the period. And my lord, regarding the regulation, my lord, one query was asked by the secretary from the director, my lord, regarding my lord his salary. And on 15 October 2024, director wrote to the secretary, the petitioner Sri Dilip Kumar Sharma is found to be unauthorizedly absent his duty with effect from 1/3/2006 till his superannuation suspension on 16/6/2000. Hence, the under provision FR 17(1), the petitioner is not entitled any pay and allowance during this period of absence. The petitioner Dilip Kumar Sharma is entitled to arrears salary and other financial benefit for the period with effect from 17/9/2006 to 6/3/2007. That is the date on which first proposed notice was issued. The period with effect from 7/3/2007 to 30/6/2014. That is the date of superannuation may be considered as unauthorizedly absent. Sorry, Mike. Unauthorizedly absent in his duty, and as the petitioner Dilip Kumar Sharma failed to respond to proposed notice issued by the authority concerned and the newspaper publication, hence he is not entitled any salary and other financial benefit, including pensionary benefits, on the basis of principle of no work, no pay. That was the conclusion of the director, my lord, before the secretary, my lord. The suspension period of Sri Dilip Kumar Sharma with effect from 17/9 to 6/6 may be regularized by creating as on duty. Moreover, the period with effect from 1/3/2002 to 16/9/6 may be breached for pensionary benefit only. It is so. Second director, before proposal. So, my lord, after going to the period, as your lordship query is that whether 16/6/2009 to 34 was regular, that was not regular. Only the suspension period was regular and other was considered as unauthorized action, my lord.
That's all right. You can regularize it only for the purpose of pension.
Yes.
He has not paid for any salary for that period. So you could have obtained instruction that whether that period could be regularized by the authority or not.
They can regularize my service by giving me, by adjusting the earned leave, commuted leave, and if necessary, extraordinary leave, which is permissible. Lordship, if I am taking your lordship to 2025 SSC online, SC 3434, Jaya Bhattacharya appellant versus State of West Bengal and others. Para 11 and 12 I am referring to. Para 11 and 12. Here also inquiry was not conducted.
Regarding the pension, my lord, already proposal has submitted, my lord, on as he is in judicial custody, my lord. His signature is required, my lord.
Everything has been done, Lordship. We have already
Yeah.
signed. Does.
So last order
Let's have it. Yellow was Yellow and seal of Muhammad.
like recently, sir.
All agree, human pensioner paper to you with you.
No, last photo order has to take government of ridiculous.
It will be.
Yellow for a signature.
I do publish or November. Convert a woman of paper.
Mr. Thor, whether the petitioner had such amount of leave in his account?
That the respondent authorities can calculate how much
After
period of
calculation, my lord,
Yeah.
80,000 something.
No, no, leave,
Leave.
unleave and commuted leave, Lord.
My lord, that was not.
They can calculate, and after calculation, they can adjust it as for the period of pensionary
Substance
benefits.
is allowed.
And if it is not sufficient, if those leaves are not sufficient, they can grant extraordinary leave to the petitioner for regularization of that period. For extraordinary leave is only for the purpose of pension and other benefits. Here the citation I have referred, Lordship, here already extraordinary leave was granted. Since no inquiry was made.
Prefer two petition?
Lordship,
Why you have preferred two petition?
preferred one is for subsidiary allowance and another for pension and other benefits.
Subsistence allowance already paid, my lord, my way, that petition is become infructuous, my lord.
No, that Lordship will decide whether subsidiary allowance is admissible up to from 16/9/2006 to 36/2014 or not.
Regarding, my lord, delay to approach before the court, my lord, on 30/8/2024, the coordinate bench of this honorable court already put a question whether his petition is maintainable or not. Regarding delay to approach. 30/8/2024, my lord. Ito yun ang order. No, hey, order tas delay is also.
Particularly several point of time these petitions came up before.
If the cause of action is continuous, then the question of delay does not arise.
Right.
What I respectfully submit.
We are disposing of both these petitions then. We issue direction to regularize the period.
Yes.
By granting this whatever leave available in each account. And if not available, then you have to grant this extraordinary.
Yes.
And subsistence allowance, admittedly, he has not been, the suspension order has not been revoked.
Revoked. That
His
is what.
superannuation. Then you are bound to pay the subsistence allowance.
And
It is your fault.
are not finalized because due to my lord, he has not submitted focus reply, and my lord, he is untraceable, my lord. So I have found it. So, lordship, my humble prayer is before passing order, my lordship may go through the, my lord, I have.
Pardon?
Before passing any order, my lordship may go through the record. It's found. So I have take my seat, my lord. So maybe.
No, that's all right, but admittedly, suspension order was not revoked.
Yes.
Till his superannuation.
Yes.
That reason also.
If it is not revoked, then you are bound to pay the subsistence allowance.
And before the issuance of the show cause notice, they should have revoked that order of protection.
That was not concluded, my lord. There's already 2 FIR was lost against the prisoners, and the newspaper publication
That's
also.
all right, you could have revoked the suspension order. Then initiate departmental proceeding. Anyway, Mr. Thor,
Lordship.
you submit him a copy of this judgment you have relied upon. And you inform me later on, but we will not hear you again. During the course of the day, you inform this court, having gone through this judgment. What is your view on that point? Okay.
Lordship is keeping it CAB.
No, we'll pass the order.
Lordship. This week, Lordship, or after vacation?
No, Anytime it can be uploaded.
Lordship, obliged.
May please conclude about it. Lordship, here, instruction is still awaited. You have to file our affidavit. So I pray for 2 weeks time, Lordship. Recommendation.
2 weeks time.
Lordship, even in the last occasion, they have sought for some time. Lordship, it was filed on 8/8/24, your Lordship.
Lordship.
And notice was issued on 12/8.
Well, I'm not
No,
calling Mr.
Mr.
Engineer.
Sharma, you have received the instruction,
Lordship here, Mr.
the
Attorney has already communicated Lordship and partial instruction was submitted, some clarification from the HSO was sought. And after that, they will be providing us the wise report, Lordship.
okay, we are granting you time, but you have to pay some cost.
Well, this time, Lordship, last time, by, after opening Lordship, we will be filing. So Lordship allow.
Art Mr.
And Sharma, your Lordship.
And Sharma, Lord, I voted for the petitioner and Mr. P. N. Sharma, Lord, I extending of. You are for 1 and 2.
Lordship, I am so honored.
Who is for 3 and 4?
3 and 4.
Lordship, on last occasion, one Mr. H. Borua appeared for 3M.
3 and 4 after.
None appears for the respondent number 3 and 4. Mr. Sharma submits that he may be granted 2 weeks time to file his affidavit in opposition. Where is allowed for the last time.
Lordship.
This is the method immediately after reopening of the petition.
Lordship, if a date can be fixed.
The event of failing to file affidavit. In the meantime, the court will proceed to hear and dispose of this petition without the affidavit of the respondent for this month.
Lordship.
Deeply obliged. May I please, your Lordship. Lordship, I'm appearing for item number 23.
Okay.
Lordship, in this matter, we have filed an affidavit. We have served them a copy, my lord. I think the affidavit is not on record. So Lordship will fix it after the vacation, my
Any date after vacation, your
my
Lordship.
lord. After 15th, May. Any day after.
The date may.
As agreed by learned advocates of both the parties, it is provided that this is occurred immediately after reopening of the petition. Registrar also take the affidavit in opposition filed by Mr. Coco. Learned standing counsel for the
Lordship.
This occurred immediately after reopening of the petition.
Lordship, kindly a date may be fixed, your Lordship. Because on item number 24, they have taken a stay. Oblige, your Lordship.
24, item
My
24.
lord, I am appearing for 24, my lord.
Your
And
call?
in item number 23, my lord, I am respondent number 7, my lord.
Okay.
My lord, I have also received, my lord, copies. And my lord, in item number 24, my lord, one interim order, my lord. It may be continued.
In 24, you are the petitioner.
Yes.
Art Mr.
K.I. Mazumdar.
K.I. Mazumdar, learned counsel for the petitioner. That Mr. Coco, learned standing counsel for the respondent. Okay. Art. Registrar raised this matter immediately after the opening of the petition. And the interim order passed earlier. Then continue. So do we take this matter with the other matter?
Yes.
17th. Keep the update.
25.
Right, please, your Lord.
Little accommodations with them. That is sort of the cap up after vacation, immediately after vacation for I hearing. Because I could not prepare the petition because of holiday, the office was also closed. I
They have filed, otherwise pleadings are complete. I have also filed affidavit. They filed a reply. In reply, they have very certain things, madam. I need to clarify on that. So,
My lord, in this case, my lord, I had to come from Delhi to argue this case. On the last occasion, my lord, on Monday, my lord, 22nd, it was listed, no such submission was made. Now, my lord, when they have found that I have come, now they are making this submission.
last time, my lord, kindly see the record, order, my lord. Last time, the
My lord, let me
did
complete
not
my
reach,
part
my
if
lord,
your
this is
lordship
paucity of
permits,
time.
my lord, and then they will do, my lord. My lord, this case, your lordship will find, my lord, against an, my lord, selection, my lord, of the respondent number 4, my lord, respondent number, my lord, 8 in this case, my lord, to the, for appointment to the post of assistant professor of the particular college here, in violation of the government guideline and in violation of the terms and conditions of the advertisement issued for appointment to the. Now, petitioner, my lord, present petitioner, earlier came before this honorable court, your lordship will find at page 49. And court said, my lord, directed the petitioner that you filed a detailed representation ventilating your grievances, your lordship will find, my lord, at page 156, paragraph 9.
No, we are not hearing the matter today.
Now, I am telling, my lord, background matter. Now, whether they will like, my lord, in this way, they are passing the, my lord, time, your lordship, nothing more than that. Now, court said I am to file a representation and directed the director, my lord, to pass a speaking order, my lord, containing decision as to why the respondent number 8 was appointed, as to why the petitioner was not appointed. Now, my lord, director did not, my lord, do anything. So a contempt petition was filed, your lordship will find. On receipt of the notice of the contempt case, the director passed the impugned order, your lordship will find the last page, page 182. Now, is it a, my lord, my lord, speaking order, my lord? Is it containing any decision? Is it not a contempt of this honorable court, your lordship? Now, my lord, the respondent number 8, who should have, my lord, filed an affidavit, appeared before the court. My lord, she is not contesting the case, my lord. Candidate is not contesting, your lordship. It is the interesting point here. She had rather filed, my lord, an application before the Deputy Director of Higher Education, my lord, withdrawing her candidature because she knew that she is not eligible for selection or appointment to the post, your lord. Now, director somehow, my lord, she is interested to appoint the respondent number 8, your lord. So an affidavit has been filed, my lord, stating that I have not yet taken any decision in this connection. So the writ petition is premature, your lord. Is it not contained, my lord, of the order dated 29/4/2024, my lord? Your lordship will see, my lord, at page 156 and 157. Court said, my lord, that you are to take a decision. As back, my lord, as on 29/4/2024, my lord, paragraph 12 and 157. Now, my lord, they are saying we have not taken any decision. That is my grievance, my lord, prima facie, your lord. Now, my lord, day after tomorrow, I am going back. And my lord, every time, my lord, it is not possible, my lord, I am practicing before the Honorable Supreme Court, your lordship. Now, my lord, I think that it will be disposed of because during, my lord, 2 or 3 days, my lord, after my coming, it was listed. But no such submission was made. Now, today, my lord, first time they are saying that we are not ready. And my lord, pleadings has been, my lord, interchange between the parties. If it's ready, what is the harm in hearing it? What is the use, my lord, to keep the this particular case, my lord, covering over, my lord, the minds of the petitioner and others?
Mr. Dasa, you can argue the matter tomorrow or day after tomorrow. Because he is from Delhi.
Tomorrow, my lord, if they do, I am ready, my lord. By 26th morning, my lord, I will be going back.
Well, first of all, my lord, I respect due respect with the senior matter. On last occasion, my lord, kindly have the order. Due to paucity of time, this matter should not be taken. Now, this question doesn't arise at all whether we
My
were
lord, I
ready or not.
submitted, my lord,
My lord,
honorable
the senior
Mr.
is submitting
Justice,
something
my
else.
lord,
And my lord, regarding this
Rajesh
not
ji.
passing impugn order, my lord, this
Rajesh.
impugn order is the order passed pursuant to the representation filed by the my lord, petitioner. He is impugning this case. And my lord, sir, regarding decision not taken with respect to the private respondent, that whether his candidature will be
Court
approved
said
or
that
not.
you take a decision.
Sir,
He is saying I have
kindly-
not
kindly-
taken a decision.
Sir, let me submit.
This does,
And regarding non-submission of affidavit
no.
by the private respondent.
Are you ready to argue the matter tomorrow?
Tomorrow,
Tomorrow, yes, tomorrow.
or Friday, my lord.
Friday I am going.
Friday he will not be available.
Friday, last day before the vacation, no, my lord, hearing will take place on that day.
As agreed by learned advocates of both the parties, that is the place of matter tomorrow at 2 p.m. there.
Yes,
Oh, like that.
highly obliged.
My pleasure, Lordship. Lordship, shall I give a brief recap of the whole issue involved, my lord? The petitioner here before is a doctor. And she's serving with the BSF. Her husband is a doctor serving with the Ministry of Health, posted at Shillong, Negrims. My lord, the petitioner, on completion of a 3-year stipulated term, my lord, was transferred. Now, my lords, while the petitioner came to know that she was being transferred, but she preferred a representation, that she wants to be adjusted here only. And now, my lord, they have neither acted on that. Then what they have did, my lord, they have issued my transfer order. Now, my lords, I have twofold prayers. One is either you don't transfer me from here, either you give me childcare leave for 365 days. That is the simple issue.
There is then you have already been released.
My lord?
You have already been released.
Released,
from
my
the
lord.
present post.
Yes, ma'am. So that can be taken care of if they grant me childcare leave. That is for 365 days.
If you have already been released from the present post of present place of posting, how can they grant?
No, my lord,
the side?
I have twofold prayers, my lord. One is childcare leave. Childcare leave means, my lord, it is my right under Article 42. What has happened, my lord? I came across Supreme Court judgment, my lord. That is, my lord, this is a Director of School Education. You open your chamber group and that citation. Though, my lord, SCC is not mentioned, the another citation is there, my lord. My lord, come to paragraph 2, short order, my lord. My lord, find there is a sentence running from although. She was found although there is no such rule, we are of the view that in effecting transfer, the fact that children of an employer studying should be given weight. If the exigencies of the service are not urgent, the learned counsel appearing for the appellant was unable to point out that there was no urgency in the present case, that the employee would not have been accommodated till the end of the current academic year. Therefore, while setting aside the impugn order of the tribunal, direct the appellant should not effect transfer till the end of the current academic year. In my cases, my lord, though there is one petitioner who has signed this affidavit. But my lord, in fact, there are 3 petitioners. These 3 petitioners, rest of the 2 petitioners are 2 daughters of this the petitioner, my lord. They're studying in Guwahati. They're in midst of that, my lord. They are not also in, my lord, CBSE. They are with the ICSE, my lord. ICSE doesn't accept mid transfers, my lord. These petitioners, daughters of the petitioner are standing here, my lord. And in spite of that, there is another fact, my lord. There is another fact that there is a policy of the central government that when 2 of the employers two of the family, one of husband and spouse, my lord. If the husband or the wife, my lord, vice versa, is employed with two different masters, my lord, there has to be a exercise, my lord, where the nearest post has to be given, my lord.
That's all right, but what is your instruction?
Lordship, 90 days CCL will provided. We have never said we will not provide it her, but 365 days as a whole at one time is not possible because it's other services it may be, but she is an anesthetist in a 50-bedded BSF hospital where all the others gynecology, surgery, etc. are there. Now we are running our hospital on a stopgap arrangement, which we cannot do for long, Lordship. And also that is a defense, so we just cannot hire anyone to serve in our hospital. 90 days have over by 13th of August. So now she is on neither on TCL nor which on anything during this period. It has to be for by another any other leave of her Lordship. But Lordship, what I think, Lordship, it is better for her to go join and submit her representation, which is the law of the land also in SC Saxena, that you have to join and then you have to place your representation, ventilating whatever the grievances. We have never said her that we will not provide, but yes, 365 days, and now there is no necessity of 365 days. The prayer that 365 days, that also done because 3 months she had availed. Transfer order she now cannot claim because she had availed alternative. 90 days we have provided her. She had availed that. That is already over on 13th of August, Lordship. 42 days thereafter.
Interestingly, that 92 days was granted, my lord, after we moved the code,
No, it's a go away.
my lords.
You go and join there.
No, my lords.
And thereafter you file a
My lords.
representation.
My lords.
That SC Saxena does
No, my lord. SC Saxena would not come in such a mechanical way because the judgment I have also placed at the Supreme Court. And my lord, SC Saxena I can assail because Article 42 is speaks about the just human conditions, my lord. Because I also have another judgment, my lord. This is Supreme Court. This is our High Court, Santana Thakuria, my lord.
This is very much there in all the other cases.
There should be
And
one
all India
element is, my lord.
services too.
Exactly, my lord, my point. In all India services, they follow, my lord, they will, in that case, my lord, there is an SR 121.2. In SR 121.2, it was brought before this Honorable High Court, though it's related to Assam service, but it's a part of 121. Lordship will find the relevant portion at 5 and 6, because we are dealing with a beneficial legislation which has to be liberally construed, my lords. SR 121 sub 2 of FRSR.
But that is
No,
state.
no, it's a go away.
My lords.
Go and join there.
My lord.
And you file one representation.
My lord.
And on such a representation being filed, they will grant you the leave.
If they give a
till
undertaking,
the
my lords, that it
beginning
will
of
be
the next
considered, my lord,
academic
if
year.
they give a consideration, because it is coming from her.
Consider it as
Consider as per
As
norms,
per
no, my lord.
the
It should be a
universal-
speaking order, my lords. It should be a speaking order. It should touch everything. Because I had a lot of judgments, my lord, when touching, when dealing with these kind of transfer issues, my lord, which is given rise to problems, it's incumbent upon them to touch everything, my lords.
because
In fact, my lord will see page 33 of the petition, my lord.
point may do some work. Then she also because in a year one can ask for three times ACCL. She had availed one. She had two more for this this current year also. So according to what days, we have never said that we will not provide. But 365 days, we have already provided 90 days out of that 365 days. But there is a
No.
difficulty that it is medical and that to defend.
Till the end of next academic year. You grant it.
But that's again in one span that may be difficulty. That may be difficulty. That is the difficulty what we are facing.
You could just I can check. And my lord, the whole background of passing that leave, giving me granted leave, because the movement order issued by the authorities was stayed by this court, my lord, by its order dated. It was ordered, my lord, 34/2015 speaking order was movement orders are stayed, my lord. That they have not filed any kind of IA for modification. They have not filed for any IA vacation of my order.
movement order has been stayed, but then at the same time, they had prayed for CCL and which we have granted, and they have availed them.
When it was said,
It was stayed, my lord, by White Order 6525.
Only not to enforce the movement order and to directing me to obtain instructions.
so she has still been working here.
My lord.
She has
Yes,
been
sir.
working here.
Yes, my lord. My lord, kindly come to page 34 of my petition.
At present, she is not working now because she was already relinquished from her post. A new incumbent had joined long back.
Under 33, my lord, I have annexed a policy, my lord, which governs this whole thing. No, it's a policy posting of husband and wife the same station.
No, that is there.
Yes, my lord, my husband is posted in Shillong. He is on a central service. He is in a non-transferable job.
She was in Shillong for 7.
I'm not
then
asking for
she
Shillong,
has
my lord.
come Here.
I'm not asking for
We
Shillong.
have to see other conditions. We are not saying that we will not provide. 90 days she had already availed, then 42 days on another leave. Almost half she had enjoyed out of the 365 days.
And after my lord, movement order was issued, stayed by this court, we wanted to join our duties, resume your duties, my lord. It's not that we don't want to do.
Anesthesis, so all.
And that apart, my lord, we are not,
It's not only one department. As an anesthetist, she is the only anesthetist in that hospital.
we are not aggrieved by our nature of job, there, everything. But issue is, my lord, these two students, my lord, these my daughters, my lord, they have to look after, my lord. They are below 18. And
CCL is
since,
18, below 18. So
and my lord, the judgment which
we
is placed, my lord,
will
it's a,
definitely be
it's
there.
a levy, it's a beneficial legislation, my lord. It has to be considered liberally.
Although she said her husband is
No.
also somewhere she has to.
Mr. Gogoi,
My lords?
account of that you cannot remain forever in Guwahati.
No, I'm not asking. I'm just asking till the academic year goes. Lordship, I have placed a judgment, my lord, that one-page judgment, which says,
Then again, the next daughter, class 9.
no, both are there, my lord. We are not going to that because of all.
Again, that will come lordship because the order is of April. So at that time, just the beginning of the now.
Group partner name, director of school education.
Defense medical specialist. Her husband is there. It's nowhere written that husband, he may be staying here, but somewhere she has to manage with her husband. He is an ophthalmologist in neglect.
This kind of submissions should not be made because, my lord, the issue we are dealing are two girl childs. It's not two male child. If they stay in hostel, that's a different because.
Lordship, it's not any other person. What is the difference between male or female when there is a mother or father's question is there?
And that judgment, my lord, Director of School Education Madras and O. Koruppat Heaven, my lord. High Court, Supreme Court has said, my lord, even though there is no rule, my lord, don't effect those transfer until the academic year. Till March, my lord, I'm asking only till March.
Exigencies has to be set out. Official exigencies
No,
also.
madam, you obtain instruction whether you can grant her leave, childcare leave in the next academic year. Or
Lordship, in that case, Lordship, let her file a representation before the authority instead of keeping it pending, Lordship.
First, you have to obtain the instruction.
Because we have in our in her 90 that Lordship may kindly see that application that CCL where we have granted her the CCL Lordship that in that also Lordship will find that we have given her and nowhere we have stated that we will not grant her. We have given her and we only our difficulty is that we give it as a 365 days. Now, that is for it to see.
Now 365 days are no longer required.
No longer required.
Only few months are there.
Yes. So let her submit her representation. They will
First you obtain instruction. You have to give assurance to the court that in the event of filing such representation, you will grant it.
That assurance cannot
Then,
because
then we'll pass the order directing you to grant it.
She has to file a representation for that because 90 days.
She will file, but you have to give assurance that you will consider it.
They will consider it as per the
So you first obtain instruction in this regard. We'll
Lordship
take up at
subsequently take up at 2.
Obligement.
Posted after, I have FSA, my lord, lordship, posted after petition in the meantime, I will file my affidavit.
You will file affidavit.
Lordship.
Third, Mr.
R.I. Bhuya.
R.
R.I. Bhuya. On behalf of Anis Mazhar Bhuya.
R.I. Bhuya, learned counsel, appearing on behalf of Mr.
Anis Mazhar Bhuya.
N.S. Bazar Bhuya, learned counsel, product. Mr. S. Bora, learned standing counsel for the respondent. SSA. Mr. Bora, Samit State. You have received the inspection.
And the discussion come, my lord, here, my lord. So, lordship is posted after vacation in the meantime, else, and the affidavit.
The Bora press for listing the matter immediately after the opening of the vacation, and in the meantime, you will write the affidavit for it. Where is accordingly allowed, let's tell it. Publication. Yes. And inspection available?
Your lordship, today morning I have received, so I'll file it within a week, your lordship, or after vacation.
No, in respect of his entire pair,
Your lordship, let it come after vacation, your lordship.
Your Honor, this is the system going on with DGCA, and I'm suffering with DGCA since 2009. So I had to come before the Honorable Court thrice. This is my fourth time. So this is happening.
This matter.
I'm the only person in this relation with the DGCA, like Pani Thaki Ghori Alo Logot Juzibo Loga. It's going on, Lordship. And I have come to know from the DGCA headquarters that
okay. Third, Mr. Victim Chena Losker, learned petitioner in person, and Mr. learned Summit that he has received inspection and the price for listing the matter after vacation so as to enable her to file affidavit in opposition. Fair is accordingly allowed. However, taking note of the submission of the petitioner in person and also the learned CTC as well as the material lesson record. Pending further consideration, the impugned order dated 13/8/2025 stands state will record this after.
Your Honor, there are 3 orders to be stayed, Lordship. That is
Your
7/8/2025 also. There are 4 orders. That is the
What is your pair in this petition?
Lordship, prayer also for 4 orders, Lordship. It is page number 87, 86, 87, 88. That is annexure 17, annexure 18, 18, 19, 20. And Lordship, annexure 22, Lordship. Prayer for this, prayer for interim relief, Lordship.
Your lordship, let this matter be come again on Friday, your lordship. Today I'll file this affidavit. Everything is ready, your lordship. Yes, today I'll file. Let it come again on Friday, your lordship.
Okay, Friday.
Lordship, one more prayer I would like to pray. And Lordship, that DGCA is doing all these activity.
No, that,
So
let her
that
file
Ministry
affidavit
of
will-
Civil Aviation should file the affidavit, Lordship. Until then, Lordship, this order may be stayed.
Let her file affidavit will.
Lordship, she will file for this one by DGCA. And I am against of DGCA, and the Civil Aviation Ministry should know. I have come to know from the DGCA headquarters, there are groupism, Lordship. Lordship, that Civil Aviation Secretary should file the affidavit, Lordship. It should known to the Civil Aviation Ministry, Lordship. The DGCA is doing all these activity, Lordship.
Yes,
You will be
Lordship.
filing your affidavit on behalf of all the four.
No, no, for 2, 3, and 4.
Not
Okay.
by
We have
one, Lordship. Let
For
it be
my
filed by
ministry,
the,
For ministry, I have to take instruction. For ministry, I have to, the respondent number 1, I have to take instruction. I'm
To obtain
filing this
instruction,
affidavit
then you file affidavit for
2, 3, and 4.
one has not yet given any instruction as per my knowledge, Lordship. The one has been kept on dark, Lordship.
2, 3, and 4, I'm with.
but whether notice was served upon the respondent number 1, we have
Yes,
already
Lordship.
issued notice.
She is CGSC. She is representing
Yes, I can
respondent 1 also, Lordship.
You file affidavit there.
For 1, it will take time here after vacation. For 1, and for 2, 3, and 4, today
Let
itself I
it
can
be,
file.
let it be filed by the
In
one,
respect
Lordship.
of the interim period, then
Yes,
Respondent
Lordship.
number 2, 3, and 4, today I am filing.
okay, you file your affidavit, then day after tomorrow we'll consider it. This open commits that you will be filing affidavit in opposition in respect of respondent number 2, 3, and 4. 3 and 4. Let's see, press for listing the matter on Friday for consideration of the interim period of the petitioner. Accordingly, it is provided that they should publish the matter day after tomorrow to consideration of the interim period of the petitioner. In the meantime, Ms. Copan shall also obtain instruction in respect of the respondent number 1.
Apply the
On Friday, maybe 2 o'clock, Lordship, if it is possible, Lordship.
Okay.
Deeply obliged.
May I please allow?
Yes, Mr. Lavuri.
Lordship, he was supposed to get it on the last occasion, Lordship, I have pointed out that they have applied in the wrong category, management. Yep. Lordship, page 28. Lordship has in the manager and Lordship has directed him to take instruction. Because they can now reapply as an private institute, Lordship. Because this government aided was giving rise to the government aided category that was stopped since 2019. Lordship.
Okay. So what is your instruction?
Lordship, I am
you will apply
Lordship, only two
the-
options are there. One is a government aided and another is a private aided, private mode. Private. So Lordship, as per the speaking order, Lordship, the mission director says the online option is available. Now I apply and the instruction said the unrecognized, Lordship, last part, the according to online application has been submitted through request ID so and so, but the application is revert back from the date state mentioning to change the management of school from the gov aided to unrecognized. But the online system does not allow the unrecognized option to be selected as a school management.
Now they have to apply in which category?
Lordship, let me file an affidavit, Lordship, then it will be clear the step by step procedure what he is required to take, Lordship. Let me file the affidavit, Lordship, and take it up on the reopening.
Reopen. Yes.
Lordship, only question is that when they are opening, they allow shoot in my online application. This was of my restriction, Lordship.
Lordship, I will explain it, then Lordship can dispose it.
Already I have submitted.
You will apply.
Yes.
In which category here, Mr. Chaudhary, in page number 28, which is the category in which he has to apply for?
Government aided, that management category.
Management category.
Management category, it will be become unrecognized or private institute.
So, in the order, we'll simply say that in the management category.
Lordship, let it be reapply if in the, because this was done on 24th October 2024. If in the meantime, some category has been changed in the software, Lordship, that I cannot say. So let them apply to the district mission coordinator. Then they will be able to guide him. Best.
District mission coordinator.
Yes, Lord.
Okay, you applied. We are disposing of this petition. Any further direction required? No, I think so. We're disposing of this.
Yeah.
Next slide.
May I please as your lordship?
Yes.
My lord, that matter relates to, my lord, the dispute as regards the seniority position of the petitioner with the private respondent, my lord. I just beg to draw my lordship's attention to one particular document, my lord, that will suffice the entire issue, my lord. My lord can straight away take page number 64 of my writ petition, my lord. As my lord got it, my lord. I am referring to page 64, annexure 13, my lord. Mal.
Yes.
As per the order of the Director of Education BTC Kukrazar, by letter number dated so and so, the 20th February 2025, the subject matter of the letter the governing body discussed in the meeting regarding the seniority in between Abdul Aziz Khan and Sayyada Habiba Rahman of their services at per discussed. The meeting unanimously resolved that as per the record of the Assistant Professor Abdul Aziz Khan was appointed on 16/11/2010 and he had joined in his post on 17/11/2010. But it is found that he has been working as an assistant professor since 20/06/2013 till date as per the teacher attendance register. In respect of the assistant professor Sayyada Habiba Rahman as per the teacher assistant so and so, she was appointed on 30/03/2012 and had joined in her post on 02/04/2012. After verification of records of both the assistant professor of so and so in the Department of History of the college, the governing body thoroughly discussed the matter and take decision unanimously that Habiba Rahman is the most senior over than Abdul Aziz Khan as per the teacher attendance register. Further, the House directed to the principal of the college to take necessary steps for correction of the teacher attendance register and forward a copy for information to the Director of Education BTC Kukrazar. Now, my lord, the dispute is very limited, my lord, regarding the two seniority position of the two assistant professor of the college. What the college authorities had done, my lord, this Abdul Aziz Khan, who is a private respondent, my lord, admittedly was appointed after me, my lord. But what they have done, they have manipulated some records, this appointment and joining, and now they are trying to supersede my seniority with this person, my lord. And when the governing body, my lord, inquired into the matter in the teacher attendance register, it reveals, my lord, that this incumbent, this Abdul Aziz Khan, has put his signature much after my date of appointment and joining. So, my lord, this is the minutes of this governing body's meeting, and basing on these minutes, my lord, the office of the principal, the principal has written a letter, my lord, to the Director of Education BTC Kukrazar is at page 69, my lord. Well, just for a moment, my lord, at page 69, annexure 15, submission of the rectification of the seniority of so-and-so of Mahamaya Degree College in the Department of History. Reference your letter number dated so-and-so, sir. In compliance to the subject and reference cited above, I have the honor to state you that the governing body of the Mahamaya Degree College have been decided and rectified the seniority of so-and-so, MA Assistant Professor, Department of History over so-and-so, Department of History, as per the governing body resolution number 7 held on so-and-so. This is for favor of your kind information and necessary action. Now, my lord, it is admittedly the principal has also written a letter to the Director of Education, but unfortunately, my lord, till date, this issue has not yet been resolved. The teacher attendance register and all other records are as it is. As a result, my lord, during the course of this provincialization exercise, which is going to be initiated shortly, now I will be ousted. And during the course of this development, my lord, the college authority, for no reason, my lord, has issued another advertisement. My lord, may kindly turn to page number 74, my lord. Annexure 17. This is an advertisement issued on, my lord, 24th of July, 2025, my lord. Applications are invited for the following post of assistant professor subject in English 1 post reserved for history and history 1 post open for all candidates. Must be MA in the subject from so and so prescribed marks. Age is prescribed. So, my lord, I am in the open category and Abdul Aziz Khan is also in the open category working. Now, my lord, our services has not yet been dispensed with or not terminated. Now, why and under what circumstances, my lord, this advertisement has been issued? This is also not clear, my lord. So, my lordship, on the last occasion, my lord, when I fervently prayed, my lord, for the stay of this recruitment process and as well as other, my learned friend on the BTC was not there, my lord. That's why this matter is posted again today, my lord.
Yeah, Mr. Bora.
My lord, basically his grievance is against the college. In the now from that college has issued an advertisement and this is also put into challenge. What will come to the area of parties, my lord. What will come to page number 5. Neither the government principal, neither the college, neither the DB is a party. It cannot be, my lord. You have to erase this. Since the grievance is against the principal advertisement, you have to put the college on within the party for college and college DB or the.
Yeah, yeah.
My lord, it is. My lord, it is escape my sight, my lord. My lord, I will.
You filed on petition then?
Yes, my lord, petition I will file, my lord. My lord, just although I should not pray at this stage, my lord, if my learned friend take a trouble to call for the instruction, my lord, during this course, I will also make an application for this implement, my lord, by the next date. By the next date, my lord, my lordship can consider my IA also, my lord.
Okay.
And my lord, I am just praying that if my respected friend bring the instruction from the director, BTC, he can represent, my lord.
BTC can do, but principal is the.
No, that is correct, my lord. That is my fault, I admit, my lord. But the once the letter of the BTC is there and the matter is now pending before the BTC as per the letter of the principal of the college, my lord. Now he is representing the director of the BTC. That what happened to that communication, my lord? That instruction my respected friend can bring before my lord, my lord. The letter, my lord, which I am referring is at page 71, my lord.
Okay, not 71.
71 is the type of document. It was in the meantime, I will implement. Join everything. 40 will.
Notice is yet to be issued here.
Motion, my lord.
Motion, I
Ultimately, my lord, what to say? That area of party has to be corrected, then motion, then only you can give the
Notice
instruction.
Heard, here, punya learned court of it. Sorry. Yes, Bora. Learned. Okay. Of that it. Sir Bora has pointed out that in view of the delay being sought for in the present petition, the principal and the governing body of Mahamaya Degree College
Mahamaya Degree College in the
Degree
district
College.
of
are necessary party
my lord.
in this rate proceeding, but the same, they have not been allied as a party in proceeding. And in order to adjudicate the dispute effectively, it's necessary that the principal and the governing body of the college shall be allied as a party in this matter. So Bhuya Learned Council for the petitioner submits that he will take necessary step in improvement in respect of the improvement of the governing body of the college and also the principal of the Mahamaya Degree College by filing an interlocutory application immediately after the opening of the. Accordingly, it is provided that register is the matter after the opening of the petition. In the meantime, Sabora learned nothing for the PTC shall obtain necessary instruction in respect of the later dated
month. Page 71, my lord.
In respect of the letter dated 8/5/2025, addressed to the Director of Education PTC further by the Principal Mahamaya Degree College, Bogibadi, and also in respect of the advertisement dated
Mal. 23/7/2020.
23/7/2025.
Mal.
This is the matter after reopening.
Mal.
Timing item
Obliged.
11.
Why, madam?
You can.
Eleven to कौन पे
Transfer.
किसने नहीं रिलीज किसने नहीं चलिए You know how he can override. कितने enrollment वालों को नहीं मिले इतना more release भी कौन
Yes, there is shortage of teacher.
That is the reason why.
But can it be a ground?
No, my lord, he cannot.
He has to release.
He has to release.
Because it's the order from the DSC allotted and he has to act upon it. However, because the reason that he has given, because there are only 3 regular teachers and only
इतिहार नहीं मिले
2 tutors, your lordship.
He can write a letter, my lord, to the director.
Lord.
But my lord, that has not been done. It is his own decision, my lord, that there is a shortage of teacher. I cannot release you. That is in one kind of, my lord, willful disobedience of the higher.
We'll direct him to release
Mal.
in a period of 1 week from today.
Mal.
This was the
Mal. Obliged.
Items for orders. Item number 29. Carter made.
Lordship may pass over for time being, your lordship. In this matter, Mr. Kengkari would like to appeal.
My lord, I am sorry, my lord. In the earlier matter, there was a 10 days time in the transfer order to, my lord, go and join there. That 10 days is already going to be over, my lord. That may kindly be.
we'll direct the director to extend it.
Yes, sir. Mal. Obliged.
I'm praying for time being in item number 29, your lordship.
Okay.
Much obliged.
The federal lordship that notice has not been issued to the newly incumbent.
No. Whether he has filed the interlocutory application. You have filed the amended prospectus.
Yes, lordship, I
When?
filed it, lordship, today morning because that day, lordship, already the section was over, lordship, file was not there. Yesterday, fortunately,
We'll do one thing. Today we'll issue notice.
lordship, we have taken steps only, lordship, under the presumption that the notice has been issued in the, I have taken steps, lordship, already. The acknowledgement copy is with me, your lordship.
But whether they received it.
Lordship, that will take some time, Lordship, because it has to go to the newly incumbent person. At least 2 days time it will take, Lordship.
So, without their representation, can we pass any effective order?
But Lordship, my only anxiety is that this is just a technical lapse, Lordship,
Technical lapse
technical
is there,
obligation,
but,
Lordship.
you could have rectified it much earlier.
That's true, Lordship, but the people, the persons, they are all like above 70
That's
years,
all right,
35 years.
that's all right.
They're not even hardly, they could. From Dibrugarh it has come.
Go.
Lordship.
Immediately after reopening, we will consider it.
And Lordship, I may observe that steps is taken, Your Lordship. Because I have the copy, Your Lordship, but I'm sorry, Lordship, I don't have the printout, okay, my,
Unless you produce a copy before this court,
and the order was also not uploaded, Lordship, that's why, that is the reason I was.
Order was in the IL.
Both the cases, only.
no, IA has already been disposed of.
Disposed of, Lordship, and Lordship has allowed the IA, Lordship, to imprint.
Wait.
Why? Office note, today's office note reflects the amendment regarding it. Today's of.
I would have taken on Monday only, Lordship, but because the file was in the bank, in the court, Lordship, they were not able to. Then I thought of doing it on Tuesday, but Tuesday was holiday, Lordship.
Okay, we will verify it. The course title is not available right now.
Amended person, I submit I will submit it at 10:40 to the section, Your Lordship. They called me and at 10:40.
Sergeant,
Sergeant number 30.
Next, please, Lordship. Lordship, this. Another one, Lordship. Lordship?
You have filed your
Yes,
reply
yes,
affidavit.
yes, Lordship. I filed affidavit, Lordship.
When?
Lordship, much earlier, Lordship.
Sir, proposal you have received the copy.
Yes, my lord. I received the copy, my lord. My lord, in the meantime, my lord, the department has also filed a review application, my lord. Against yes, against the order, my lord, which has been put in contempt. Because, my lord, that order was passed, my lord, in the motion stage itself, my lord. On a concession given by the learned, my lord, the standing council revenue at that point of time, as well as, my lord, the learned government advocate. Now, the review has been preferred on the ground, my lord, that the materials which also had been placed before the court, my lord, were not produced before the court. And for that reason, my lord, the court has been, my lord, paid, my lord, to go for the matter, my lord. Under that circumstances, I pray, my lord, that this matter comes after the vacation, my lord. In the
When did
meantime,
you file and what is the number of the review petition?
my lord, I will give it, my lord. I will give it, my lord. Oh, fine, my
When?
right now, my lord.
Then after vacation? Or, sir,
B Malakar.
be Malakar, that is for the, and Mr. R. Proposal, that is council for the complaint number 2. The Malakar submits that he has already filed his reply to the affidavit filed by the respondent number 2. The case is this, Mr. R. Proposal, learned counsel for the contempt number. Mr. Respondent number 2 submits that one review petition is being filed. Being a review petition number, and a price for listing the matter after vacation. There is according to the press the matter after vacation. You give the number to
Well,
the
right
court.
now.
Lordship, date may be fixed, Lordship. Date may be fixed. Otherwise,
23rd of October. But I'm giving the number, man. I apologize. I please your lordship. My lord, judgment and order dated 5/8/2022 passed in WPC number 4397 of 2022 is yet to be complied, my lord. Kindly see the judgment, my lord. Page, my lord, 12 starting, my lord. Operating part, page 17, para 13.
What is the status of the interlocutor application?
My lord, after this, my lord, order, I made an inquiry before the, my lord, pending section, my lord, filing section. But this morning they informed me that there is no existence of such filing, my lord. Even, my lord, on search.
It's not the IA. The IA has been disposed of. We are intending to file a review against the IA's order. There is some issues from the technical side or something because of which we couldn't file the IA properly. We had applied for certified copy, which we haven't received yet.
So IA was disposed of.
Not-
And you file application for review of the IA.
IA.
Order passed in IA.
Yes, sir.
What is the status of that
Lordship,
petition?
the filing couldn't be done properly because there was an objection from the filing section regarding the legibility of the annexure. We had applied for certified copy, which we haven't received till now. So as soon as the certified copies we receive, we'll be filing it will be filed. As of now, I pray that the matter may come up after the vacation. By then, probably we'll make an attempt to release the matter, the review.
My lord, review, my lord, file as per the, my lord, searching report, my lord, on 4/8/2025. And the concerned bench already, my lord, sitting in last few occasions, my lord. So, my lord, is a since it is matter relating to the pension, my lord. It is now retired in 2021, my lord.
No, they are going to file a review petition against the
My
IA.
lord, simply filing and, my lord, a review petition, my lord, does not, my lord, stay the order of the, my lord, single bench judgment, my lord.
No, that review petition has been disposed of.
Dispose of, my lord. The judgment has attained finality, my lord, after disposal of the, my lord, earlier application, my lord. Now, the, my lord, without stay of the higher court, my lord, they cannot stop the, my lord, order of the my lord, the present judgment of the my lord present writ petition, my lord. Since there is no stay, my lord. Kindly see the judgment, my lord. Of the my lord.
IA has been disposed.
Yes, 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 sir. I'm listening. Yeah, I hear it, only hear it. Page 2, my lord. My lord, the issue involved in this IA, my lord, whether the regularization of service would be considered from the in 2006 or my lord 2003, my lord. So it is final. It is my lord passed that the my lord the date of regularization is on 10/6/2003, my lord. So the my lord judgment has attained finality, my lord. And the other parts of the judgment of the my lord, the writ petition, my lord, remain same, my lord. Petition.
The review petition has been disposed of.
No, no, review has not been disposed of. IA has been disposed of.
IA has been disposed of. So why review is required here?
Lordship, in the IA, we had sought for a
Clarified.
in the IA, we had sought for a clarification regarding the whether for the computation of pension, which date has to be taken into consideration, the date, initial date of appointment or the date of regularization. Although the order
It is stated that it is from the date of regularization,
No.
10/6/2003.
no, the order states that the date of regularization shall be 10/6/2003. We sought for the clarification for the purpose of computation of pension, which date should we take into consideration, the initial date of appointment or the date of regularization. Since the order didn't reflect the issue, the clarification which had sought for, so we are filing a review.
My lord, the judgment of the division bench of this honorable court has two parts, my lord. Kindly see page, my lord, the 53. Page 53, my lord, the two conclusions, my lord. Para Roman 7, my lord.
No, let them obtain a clarification in this regard. From which that this pension has to be counted.
Since, my lord, the page 54 is not touched with, my lord. So, my lord, the page 51 still remain the same. Kindly see the page 54, judgment of the, my lord, division bench, my lord. This clarification made only whether the regularization is to be considered from the date in 2003 or 2006, new pension scheme or old pension scheme. So this judgment clarified that the petitioners entitled to pension on the basis of old pension scheme, that is the Assam Service Pension Rule 1969. That is to be, my lord, clarified. So, my lord,
That has not been clarified here.
my lord, kindly see the page 53.
No. Let them obtain clarification first. Thereafter, we will consider it. Because we cannot interpret the decision of the division bench. Let them obtain clarification. First, Mr. M. Islam, Learned Counsel for the petitioner, and Mr.
AK Ghosh on behalf of Mr. K. Kumar.
Learned Counsel appearing on behalf of Mr. K.
Kumar.
What? Mr. Poor, Learned Counsel appearing on Mr. So Learned Counsel appearing on behalf of Mr. K. Kumar. Submits that. So, one interlocutory application, being I civil number 37 of 2025 was referred by the contemptor seeking some clarification of the judgment and order dated 5/8/2023 passed in a writ appeal number 133 of 2023. Hence, the same I has been disposed of high order dated 28/5/2025. Yet the question, yet the clarification being sought for by the contempt of has not been clarified. And on such ground, the contempt of has decided to file a review petition for review of the order dated 28/5/2025 passed by the division. And if principal listing the matter after reopening of the application, there is allowed to submit the matter after reopening the application. Let them obtain clarification thereafter will consider.
My lord, date may be fixed.
Timing item 26.
Yes.
Lordship, my instruction is that, if Lordship, they give the undertaking that they will give the, CCL Lordship till that will amount to that allowing the repetition which they cannot because higher authorities are there. But they-
Allowing?
allowing the repetition almost Lordship, the prayer of the repetition, they directly just cannot say. But they will pass a reason and speaking order after considering all the aspects of the petition. That is what my instruction is.
Yes, Mr. Gogoi.
In that case, my lords, I often stand that side. I know what will happen. Rest I leave to your lordship because I placed a judgment also and I have said that pointed out that policy also. I'm not asking, I'm not aggrieved by the transfer. Only issue is like my elder child is in class 10 in ICSE board and ICSE board, my lord, till conclusion of exam in class 10, they cannot accept anywhere, my lord. They cannot go anywhere.
Will record her submission
My lords.
that they will consider it.
Yes, they will consider it because earlier also we have given her 90 days. It's not that we have totally objected, but to allow undertaking I can't or neither they can because higher authorities are there. They will definitely consider it by all considering her all.
My lord,
reason and
I,
speaking
before
order
that,
they-
lordship, I'll just place one aspect.
Because
another one.
rule is only for class 12. That
No, rule says my class age 18. And in case of PWD, it's 22. This judgment, it's a,
Yes, sir.
it's, this judgment, my lords, this comes from Himachal Pradesh. Himachal Pradesh government did not have the policy of CCL. So Supreme Court, while interfering, my lords, asked the the Himachal Pradesh government to induct the CCL rules. My lord, they have categorically stated what the issues faced by women in paragraph 7, my lords.
one is a disabled children in those cases and others are teachers, etc. Lordship. But here condition situation and they have also said that regarding the exigencies of service, that has to be considered.
That paragraph, and my lord, this is the CCL rule which entitle me to the leave, my lord.
No, perhaps in those cases, the petitioner was not the doctor.
Yes, not the doctor.
Not doctor.
And disabled children are there.
That apart also, my lord, admittedly, the petitioner was doctor or not doctor, there's no question. Question is the petitioner was a lady who had children. And the, my lord, the rules, my lord, I have just placed the rules.
One
It
children
says, my
is
lords,
disabled. Disability is
18D, my lords. Lordship will kindly go through 18D. Subject to the provision, CCS rules, my lord, subject to the provision of this rule, a female member of service and single member of service may be granted childcare leave and authority to sanction leave for a maximum period of 30 days during entire service for taking care of 2 eldest surviving children up to the age of
Rule is
18 years.
there, but
Yes.
they have also expressed their inability to.
In that case, the argument which is coming from the side that I can spell it, but once my children cross 18, which is in the case of my elder children, my lord, once it cross 18, I cannot avail these leaves. And the other judgment which I place, my lord, this usually one page just one page, my lord. It still holds the field. Even absence of rules, courts can and court has advised that during the currency of the period, academic period, this such kind of orders may not be enforced. That one page, only one page. I have no issues, my lord. Once my daughter the elder daughter, my lord, not even not proceeding for the second daughter also. Once my children, she appears in a final exam, which is stated to be in March, I'll go and join wherever they want, my lord.
No, first you go and join there, you file CCL application, they will consider it.
Okay, that they will do. Because we have
Because
already.
you have already been released from here.
No, I wanted to join here also, my lords. I wanted to work here. My issue is,
After being released from here, where is the question?
my lords, the issue at hand is, I have a communication, my lord, I've written to them that let me work here because,
Mr. Gogo, you
my lord,
cannot
we are
blame-
traversing in a different direction because if I have to argue that point, I have been replaced by another one who is not even at my grade. I'm not going to those disputes, my lords. Otherwise, I lift your lordship because though it's admittedly she's a mother, the rules also entitle me. I have to place 2-3 judgments also of these honorable court, Supreme Court also.
No, but these cases are factually different
Yes,
from the
factually
present case.
different.
Well, factually, it might be different, but what comes out from what we can call out from the principle remains the same. Factually, it would be different because sometimes
They have not rejected your pair. They have assured that they will consider your pair.
We have
let that assurance be recorded, my lords. On that undertaking, we'll go and join and file and come back, my lords, because daughters have to be attended here, my lords.
Yeah, we are disposing of the.
Lordship, let her submit a representation within 2 weeks, and we will decide it within another 2 weeks.
No, as soon as practicable. you
Lordship,
decide it.
Lordship,
This will be the-
There's
Lordship, may kindly my submission, my
yes,
affidavit is there, Lord.
I will
Okay.
record.
always, my lord. What is
May I please, the lordship. As per the last order, lordship, I have filed this additional affidavit and bring the last order, lordship.
The day before yesterday, you have cited 2 grounds.
Yes,
So, what are those grounds?
lordship, that is in my affidavit, lordship, I have stated, lordship. that
Paragraph number?
Paragraph number, lordship, lordship 9.
Hmm.
9 and 10, lord.
So this is one of the ground. What is the other ground?
Lordship, then another ground, Lordship, my submission is that, Lordship, this, as per this direction of this honorable court, is in this directions, Lordship, it is clearly directed that as per the notification 2003 notifications and as per our judgment of the Uptown Command judgment, that two part, Lordship, that is judgment as well as notifications, case and petitioner case shall be strictly considered, Lordship. So as per these directions, they did not done, Lordship. And in this judgment, Lordship, it also categorically mentions that when the school was, petitioner was appointed, that school was a Bhansar school. And subsequently, Lordship, it also came into observations by this honorable court that when some teachers are dropped, their service has not been provincialized. And then Lordship government.
Where is the OM dated 13/1/2003?
Lordship, that is Lordship in main rate, Lordship disposed petitions, Lordship.
It is there.
Yes.
Page number.
Lordship. Lordship, the page 49, Lordship. And so far, Lordship, next second ground, Lordship, whatever they have taken, Lordship, in rejections, Lordship, that provision is not applicable in this present petitioners. That's because, Lordship, this honorable court has been after gone through this all the site, Lordship, all the notifications and the records. This honorable court has been directed to examine the present petitioner is covered under the pursuant to the notification 2003 notifications. And they did not challenge, Lordship. That observations they did not challenge. So once they did not challenge the finding of this honorable court, they cannot take in the stand in this contempt matters, Lordship. And Lordship, regarding this drop teachers, Lordship, it also reflected, categorically mentions in this judgment, Lordship, and that is paragraph number 13.
So here,
13, Lordship,
You-
Lordship,
Mr.
main
Katonia,
contempt case, Lordship, that is page 11.
Sir Katonia, have you gone through the affidavit filed by?
Yes.
So you admit that the ground the present committee has taken was earlier set aside by this court, right? Will not accept this order. You have to comply with this order. You have to produce the compliance order before this court on October 17.
Lordship, if possible, Lordship, this matter may be taken on 15, as because on
Taken
15,
up?
15 October, Lordship, if possible.
Okay, 15th October. You produce the compliance order.
Obliged, Lordship. Highly impressed.
My lord, the idea was that the balance they will pay in 3 installments. No, nothing is forthcoming, my lord. Last order, your lordship's order was of June, my lord. What order will be at this, no? On 9/6/2025, my lord. Lordships indicated that 10% was paid. So balance, my lord, and 90% would be paid in 3 installments. So now, my lord, more than 3 months have elapsed. I don't know, my lord, they're constructing flyover, the flyover. Every Wednesday we hear, today so and so amount has been sanctioned for so and so. I don't know why, my lord, this amount could not be paid for the last 5 years, 4 years.
But Mr. Chaudhary,
My lord,
this amended cost title has been filed.
yes.
So are we not supposed to issue notice to newly implemented incumbents?
That is, of course, there, my lord. That is an,
First, let notice go. That is, it says. We will direct them to remain present in the court.
yes, yes.
But not today. First, let notice be served.
My lord.
Or Mr. Can put certain thing of consequences by Mr. D data. Sir, here no will be certain. One was for no one. So totally have three. Pursuant to order of this court dated 1/9/2025, amended cost cycle has been filed. And what Narayan was Dr. Paramananda Sunod and joined on earlier revenue rating as respondent contempt order number 4, 5, and 6. Let notice be issued to the newly inflated contempt order by registered post with ADM also by nodal process with today. Mr. Sir Das, learned counsel, assisting Mr. Chaudhary, apprises court that step has already been taken. Step has already been taken. Accordingly, it is provided that the is the method on 16th of October.
Please, your lordship. As for petition of ballot, the service of the respondent number 4 and 5 awaited, madam. Awaited service of the respondent for newly implemented, madam, 4 and 5.
Okay. Notice was not issued earlier.
Earlier, but subsequently, my lord, incumbent has changed, my lord, therefore I amended, my lord, and I'll amended cost title, my lord, including the state respondent, 4 and 5.
No, whether notice was issued to the newly implemented incumbent.
I have already taken, my lord.
You have taken.
My lord, taken.
Okay. Heard, Mr. Adjari learned counsel for the petition and Mr. A for respondent number 3. Respondent number 3. Respondent number 3. 1 and 2. Anybody for 1 and 2?
My lord.
Okay. Okay. Office note dated 22/9/2025 indicates that neither ID card nor unserved notice to the respondent number 4 and 5 returned. The This is the list of matter after vacation. Awaiting service report upon respondent number 4 and 5.
Item number 35 is also same, my lord. Item number 35. In this case, my lord, kindly peruse the order dated, my lord, 6/8, my lord.
Okay.
As per court order, my lord, I have taken steps for the standing counsel PNRD. But office note, my lord, stated that I have not taken step.
But if nobody entered evidence, then it
My lord, her name has not shown in the cause list also.
not yet been filed
Ithapa.
by the petition. Third, Mr. Patel, learned from the court of petition, or Mr. What is it for respondent number? 3. Respondent number 3. Mr. Horton says A, and then Mr. Patel, learned from the court of petitioner, commits that he has already taken step upon respondent number 4 and 5.
For standing counsel, Ithapa.
And serve the notice upon the standing counsel for respondent number
4 and 5.
you go and file an IA for correction. But no one entered evidence since the name of the standing counsel has not been reflected in the counsel list.
Right.
Standing counsel, who is the standing counsel?
My lord, as the my lord, PNRD.
As the already served notice upon the as the accordingly, it is provided that this is the list of matter after vacation reflecting the name of Mr. Escotto, learned standing counsel for respondent number 4 and 5.
4 and 5.
4 and 5 in the counsel list.
That may be fixed, my lord.
Item 36.
Wait, wait.
But item number 34 and 38 same, my lord. Order, my lord, contempt. Let's take along with 34 and 35,
That's it, sir. Let both the method is
my lord.
I'm appealing for item number 6. Oh, sorry. Response number 6. Whose time is granted to file our appointment?
respondent number 6.
Private.
And you for 1 to 4.
My lord, in respect of respondent number 5, my lord, one office note is there, my lord. Office note dated 28/8/2025, my lord. The service is completed, my lord.
5.
Yes, my lord. And he had duly accepted medical
Art
also.
Mr. Hope, learned from the petitioner. Miss, your name, please. Learned counsel appearing on behalf of the SCKL, learned counsel for the respondent number 1 to 4. That means P borrow for respondent number 6. Respondent number 6. It borrow submits that she may be granted 2 weeks time to file affidavit in opposition. Where it accordingly allowed. Mr. Hope, during the attention of this court, the office note dated 28/8/2025.
28/8.
29/8.
28/8.
28/8/2025. Submits that service of respondent number 5 completed. But no one entered appearance of behalf of the respondent number 5. This is the matter after immediately after reopening of the vacation in the meantime, Bora may file her affidavit. You have filed your affidavit?
Yes, already. But that matter may be come up as admission hearing.
services.
Shall list the matter in that column. In that column, admission hearing.
My
Okay.
my lord, may I click for a date, my lord? Any date, my lord? Hey. Election.
37.
For the board, my lord, I have received an additional affidavit filed by the of 22nd September. I would like to put a file decline.
Arjun Das. May it please your lordship. Here your lordship, joint secretary to the government of Assam has written the letter, your lordship, to DSA. Your lordship, pertaining to this, your lordship, and thereafter, your lordship, on dated, it's very recent order 22/9/2025. That was school education. DSC has forwarded the matter regarding Darpan portal accessibility in regards to petitioner schools to the Secretary Assam, as well as School Education Board. So, your lordship, it was compliant.
No, as far as government is concerned, they have complied. It appears from this letter, my lord.
I would like to please it.
But my lord, the Assam Secondary Education Board, they have not. Now, if your lordship would kindly permit me to place the order just to appreciate. Now, from this communication which has been placed by my learned friend, it's a fact. Government has complied with the order because they have asked the School Education Board to give the permission. Now, please come to the impugned judgment, my lord, at page 83. Paragraph 34 towards the bottom of the page, page 83. In view of the foregoing discussions, I am of the considered view that the respondents are deserved to be directed to consider the case of the petitioner for according permission and allowed to conduct admission for higher secondary first year class and onwards in their respective schools. Accordingly, respondent authorities, namely Secretary to the Government of Assam, Secondary Education Department and Director of Secondary Education, as well as Assam Higher Secondary Education Council, are directed to consider the case of the petitioner within a period of 3 months. Consequently, the impugned order dated 14/9/22, issued by the Secretary to the Government of Assam, Secondary Education Department, the impugned communication dated 3/6/24, issued by the Director of Secondary Education Assam, and impugned order dated 8/1/24, issued by the Director of Secondary Education, are hereby set aside and quashed. So, my lord, earlier government took a stand that required permission was not given. Now that order was set aside. Now, if your lordship would kindly take the additional affidavit which we have filed, my lord, I'll just place the 3 later which was set aside by the Honorable Court. Additional affidavit at page 99, my lord.
Yeah.
Now, this was the communication given by the government to the director with reference to the above. I am directed to clarify the government letter dated 22/4/21 is not permission in respect of the 20 number of higher secondary school. Now, this letter was interfered with. Now, in spite of this, my lord, this Honorable Court interfered with this letter and directed the state government, director and this council to, my lord, implement the order, consider our case. Now, the government has apparently, my lord, asked the higher secondary, it is the higher secondary council who will give the permission to give it. Now, it is a higher secondary council alone who is coming in the way, my lord. Now, the higher secondary council's order, এখন কোটবল যেখান দিছে পিছত আমাক দি দিলে ইয়াতে দিলে ইয়াতে কোনটা এখন page 97, my lord, of the that additional affidavit. Now, the same reasons which were earlier given, which were interfered by this Honorable Court, has been reiterated. This is the order. Now, I'll read last 3 para, my lord. Whereas it is pertinent to furnish that board remains committed to facilitating due process and one such required provisional registration in case of private institutions and the order of provincialization issued by DSC in case of government provincial institution is issued from DSC competent authority, the provisional registration and affiliation will be accorded. So now since government has given, let the matter be called day after tomorrow, let my friend Sutia take the instruction, Mila.
Here you
Now since government has directed them.
to examine
No,
the
but
matter,
this
your
letter, this letter, I have this letter, he had not compliance of sort. Only secretary, that's the deputy director of secretary education and the secretary to the board. So you examine the matter. That is after to examine this case and take necessary action as per letter 5/8/2025. You are requested to examine the matter and take necessary action according. That is the letter communicated to the director and also accept. But I will obtain instruction if it is that, Malad. I will immediately after opening of the terminal, I will apply the court, Malad, the course of the bank.
Okay, Milord, on reopening.
Reopening.
Milord, my only concern is, Milord, all these communications were interfered with. They have not preferred any appeal. Now, can they resort to the same very reason, Milord? That's the only part. And let it be, let my learned friend have the instructions on reopening, Milord. Yes. Okay.
Can we fix it on 15?
Yes, Milord.
Can new council assisted by Ms.
Punara,
For the Ms. Peters, council for the respondent number.
Lordship, today we are going to file wakalat
There, Milord, respondent number, I'll indicate, Milord.
1 and 2.
Oof, yeah. I think Milord Narayan Kaur
Narayan
and Mamata Hathi,
Mamta Hujai, 1 and 2.
1 and 2, Milord. And my learned friend Sutia appears for 3.
For respondent number 3, respondent number 3. Mr. Sotia submits that he has received a copy of the additional affidavit filed by the petitioner. Then he applies for listing the matter after immediately after reopening of the application.
Yes.
To update necessary instruction.
Yes.
There is accordingly allowed.
Your Lordship, your Lordship later has been kept on records here.
Okay. This does during the course of hearing has produced a letter dated 22nd of September 2025. Then submits that the order of this court. So far, the respondent number 2 and 3 are concerned has been complied with.
1 and
1 and 2, Milord.
1 and 2.
1 and 2. 1 and 2. Let the letter be marked as Annexer A and shall be tagged with the report.
Deeply, Lord.
Deeply.
May I please, Your Lordship? Lordship, this is regarding non-compliance of the order dated, order dated 21/3/2025.
Whether
That is
notice was served or not.
Lordship, we have taken steps for service of notice.
Heard, Mr.
SN Tamuli.
S.N. Tamule, learned from the Court of Appeals. Office note dated 22/9/2025 indicates that neither ID card nor unserved notice issued to the respondent number 1. ID card in respect of respondent number 1 has been received. But neither ID card nor unserved notice in respect of respondent number 2 has been received. It appears that a notice upon respondent number 1 has duly been served. But no one entered appearance on behalf of the number. List the matter after vacation awaiting service report in respect of respondent number 2. Or you want to take fresh step? No.
If required, Lordship, we'll take a fresh step.
Right.
Yes, Lord.
Later on, Mr. Tamake submits that he will take assistive of respondent number 2. Accordingly, it is provided that step be taken by registered post with ADN also by usual process within 2 working days from today. Please after for
Lordship, by speed post, probably by speed post, because registered post has been already merged with
by
speed.
speed post.
Made previous Lordship, we have filed this IA for praying for interference of this honorable court by giving direction to the opposite party to release the salary of the petitioner, Lordship, which has been kept in abeyance since September 2024 till date, Lordship. And in the main petition, we have challenged the transfer order of the petitioner.
Third miss,
B. Devi, Lordship.
learned counsel for the applicant. And Mr. Bora for respondent of opposite party number.
All the
All the opposite parties. The interlocutory application is deferred by the applicant. Wow. Issuing direction to the opposite parties to release the salary of the applicant, which has been withheld without any justified basis. Thereby thereby compelling the thereby allowing the applicant to continue discharging his duties at Dholai DHC, holding the post of SDMN in view of the interim order dated 23rd of September 2024, passed by the court. Mr. Bora, why the salary has not been paid?
My lord, I have to obtain instructions, my lord. They can serve me a copy, my lord. I'll obtain instructions.
Mr. Bora, learned standing counsel for the respondent, not for the opposite party submits that he may be granted some time to obtain instruction. However, Mr. Bora submits that the applicant may be directed to furnish a copy of the application to him. Accordingly, it is provided that the applicant will furnish a copy of the application to Mr. Bora during the course of the day. Course of the day. This is the list of matter on but for this.
Let it be on 29, my lord, because in the meantime, vacation will be there. I have to obtain instructions. And otherwise also, my lord, because
Vacation, court will reopen on 13.
yes, my lord, we have to communicate, my lord. Let it be on 29th, my lord.
Why so long?
Salary has not been paid for the last
Lord,
1 year.
petitioner is in this place for last several years, and status quo order, because my lord, on the merit of the case, status quo order has been passed after he has been released, my lord. So he is not working anywhere, my lord.
In fact, Lordship, he was not allowed to work at the place where he was
Because
working
status
in
quo
spite
order
of the
was-
status.
And by that time, he has been released, my lord. Before issuance of the status quo order, he has been released, my lord. Anyways, I will obtain instructions, my lord. And in fact, my lord, the entire petition needs to be taken up for final consideration. Because otherwise it is, it will be a problem for the petitioner also, my lord, because status quo order has been passed after he has been released. And he is not working anywhere. Anyway, let it come on 29, I will obtain instructions.
Okay, 29. But concerning the salary of the petitioner.
It has been
Salary
paid.
that I have to obtain because, but the thing is that as per the records, as per the orders, on that day when the status quo order was passed by this honorable court, he has been released from his post, madam.
Then you could have filed one application before the court that before passing the status
No,
quo
my lord,
order,
that's why
person concerned is
we have-
released.
No, we have filed affidavit, madam, and in the affidavit we have brought that on record. So that's why I pray that, my lord, the entire matter may be taken up for consideration, my lord. And otherwise also the urgency is there because it is a transfer matter, so it should not be kept for a long time, my lord, pending, my lord. It is
No,
a-
that's all right, but if the matter is not listed before the court, then
Yes, my lord.
it is pending since the year 2024.
Yes, my lord. That's why your lordship may post the matter on 29th, my lord. I'll
This is
say
the
that
this matter on
instruction.
29th, along with WPC number
Yes, my lord.
2902 of 2024.
On which,
On
my lord.
that day, an endeavor will be made to finally hear and dispose.
Yes,
of it.
ma'am. Yes.
Dispose of both the IA and the.
Deeply obliged, ma'am.
May it please your lordship. Your lordship, I pray for adjournment of this matter, your lordship. Both the
Why?
conducting councils are on lakes, your lordship. Both the conducting councils are on lakes in another court, your lordship.
You cannot argue the matter.
Lordship, he is conducting the case, your lordship. And
You are
it's a
not
part-
conducting the case.
Yeah, this is the part hard matter, your lordship.
P. Portafor, learned counsel, appearing on behalf of R. Goswami. Learned conducting counsel for the appellant. Principal, this is the matter after petition. The pair having not been objected by Mr. Singh and Ms. You are for respondent number? 1 and 2.
I shall for respondent number 5, madam. State one.
And respondent number 5. The pair is then allowed. Let us update the method.
Obliged.
May it please your lordship, my lord.
Yeah.
My lord, look, the issue involved here is very small. In fact, I am praying for a similar relief, which has already been granted by Assam Administrative Tribunal to some of the professors. And that was affirmed by the High Court also. That was challenged and affirmed by the High Court. The small issue is that they were initially appointed under 3F, thereafter regularized. Whether that 3F to regularized period will be counted while granting cash benefit or not. They have already got
While granting,
career advancement scheme benefit, while that will be counted or not. Already Assam Administrative Tribunal in the matter of similarly situated person has allowed that benefit. And the judgment of the Assam Administrative Tribunal was carried to this honorable court, and this honorable court, my lord, upheld that judgment. So we are basically praying for similar benefit that has been granted to those persons, my lord.
Today, I pray for 2 weeks or 3 weeks time today, but this matter after 2 weeks or 3 weeks. If the takeover has
Mr.
been.
Govildar, you see, if the matter is already settled, then why should we keep the matter
Lordship,
pending? This
some
is a
judgments are there.
2015 matter.
Lordship, I agree, Lordship. Some judgments are there in our favor also, but we could not negate it today, Lordship.
So
may I-
if the decision of the tribunal is upheld by this court, then
Lordship, that can be distinguished by those judgments. So some judgments are there, Lordship. We have discussed in that, I think, in the morning. So, Lordship, at least one time in the next day, Lordship, maybe observe that on the next day it will be.
Judgment depends upon the facts, my lord. Judgment depends upon the facts, my lord.
Today, Lordship, because I am handicapped today. My humble request.
Otherwise, my case is
Any date will
completely
be-
covered. If your lord,
okay, let it be on 13th,
13th.
13th of October.
Lord, in that even may I pray that lordship will keep the matter as per heard because
Okay,
absolutely clear, my lord. Yes.
Third, Mr. Das learned counsel for the petition. Mr. Govildar for respondent.
Mr. K. will argue that.
Yes, you are for respondent number.
Phone number 1, accept the
125.
125, then Mr.
One,
Is Soma, learned counsel, appearing on behalf of ED Nayak.
1 to 4.
For respondent number 6.
No, there is no for respondent number 1 to 4 I am appearing. 1, 2, 3, 4.
What?
5 is Cotton University.
Mr. Tobelder submits that the matter may be listed immediately after reopening.
Not,
Yes, today he is handicapped to argue the matter.
not.
That is accordingly allowed. That's the matter on 13th as part 30.
Not. Obliged.
14th. Tuesday.
14 hearing date. Fine. Maybe kept as part.
Okay.
Highly obliged.
Obliged.